from an objective perspective. It's not a question of subjectivity. Did they comply with the law on their version? And they put up why they complied with the law. They put up why the detention, the current detention, and the leading up to it is lawful. And your Lordship will consider, is their justification objectively good or bad? And we submit it's bad on their version. Now, my Lord, I want to go to a third point, which is what I call the Fed Sure point, which is a point that says that under the Constitution, no power may be exercised other than that which has been provided for in the Constitution or law. No official in the South African state may take any action unless there is a provision which gives that official the power, the authority to exercise that power. If the official acts outside or without the authority contained or provided for in the Constitution or the law, that official acts unlawful. I don't think that's a proposition that our learned friends would quibble with. But if I can demonstrate to your Lordship that what happened in this case, and I will, included conduct by any of the South African officials outside the law, they acted on it in that period of the 12th to the 13th of April, when our client was, and I use the words, their words, not our words, handed over. And just on that, I've given you Fed Sure, it's in our heads, but perhaps your Lordship could turn to our bundle of authorities on page 136, the paginated bundle. There's reference to a case called Muhammad. Muhammad versus the President of the Republic of South Africa and others, 2001, volume 3, essay 893. Constitutional Court judgment. It's a judgment for the whole Constitutional Court. It concerned the removal, and I use the word removal advisedly, of Mr. Muhammad from South Africa to the United States, where he was to face the death penalty. And a whole range of questions arose concerning whether the removal was a deportation or an extradition. And ultimately, the court found that it didn't really matter because whichever it was, he couldn't lawfully be sent to a country in which the death penalty was available. There's a whole range of principles that come out of this judgment unrelated to the death penalty. So your Lordship can put the death penalty issue aside and perhaps just take cognizance of the following principles. On 136, at paragraph the Constitutional Court make what I would call the Fed Sure point. That Africa must be considered in the light of the Constitution and the relevant legislation. In Hugo, this court, the Constitutional Court, came to two important conclusions regarding prerogative powers under the interim Constitution. Hugo was a case where President Mandela, what a birthday celebration or something, had given freedom to a number of people in prison. There were mothers of children who hadn't been in convictions and related to violence. And Hugo was a man. He said unviolated his rights because why should a woman get something that he would have been entitled to if he was a woman? And the Constitutional Court dealt with it. But there, the Constitution talks to this question of prerogative powers. And what is said in paragraph 31 and following is that there is no power, for example, to deport somebody other than in a piece of legislation such as the Immigration Act. There's no power to pardon somebody. There's no power, for example, in the Muhammad case, to deport him to the United States or to extradite him without a power. That is said in paragraph 32, or at the end of 31, it says that this subsection does not provide for any power to deport an alien. Accordingly, the state's power to deport relevant to the present can be derived only from the provisions of the Act.
Sorry, Mr. Cat. That is why I understand your argument to be that what happened here is that here was a deportation that was disguised as an extradition.
I'm making 2 points. I'm going to make-
Is that the point you are driving?
I'm driving at 2 points, my lord. The first argument is the whole scheme, and I'll come to it when I drill down to the facts. We will show that this deportation from Tanzania was a disguised extradition in the sense that it was collusion between the South African officials and the Tanzanian officials, where they tell your lordship it was an agreement to deport. An agreement, and we emphasize this word agreement. The Tanzanian officials, the South African officials agreed to something. That is extradition par excellence. Deportation is a unilateral act. So when the South African officials say, we've got nothing to do with this, this was Tanzania exercising its own sovereignty, a unilateral act, your lordship will scratch his head and say, well, why was there an agreement between these two countries? And just on that, if you turn your lordship's eye up page 136, you will see what I've just said in context. And I'll turn to my other point about the Fetcher prerogative point after that. But what he said at the top of the page in paragraph 28, in principle there is a clear distinction between extradition and deportation. And there's a reference to a number of books. And then he said extradition involves basically 3 elements. Acts of sovereignty on the part of 2 states. 2 states, we emphasize 2 states. A request by one to another state for the delivery, and the delivery of the person concerned for trial or sentence in the territory of the requesting state. And then there's that's extradition. 3 elements. Then it tells you, the court tells the world, deportation is essentially a unilateral act of the deporting state in order to get rid of an undesired alien. The purpose of deportation is achieved when such alien leaves the deporting state's territory. Importantly, my lord, the destination of the deportee is irrelevant for the purpose of deportation. The facts here demonstrate clearly on any version this was extradition. That's it. That's our case. I could actually sit down now, but I'll need to drill down to the facts. Let me just add to the... So that's our case. Nobody can get away from what happened here. The police had an 8-member team who, in their words, deliberated with the Tanzanian officials as to the way forward. That was on the 10th of April. On the 12th of April, perhaps I should just turn to the words right now. What happened on the 12th of April, and I'll turn to 2 paragraphs on the papers. Mr. Matthews tells the court, on page 172, paragraph 28, Mr. Matthews says the following words. Mr. Matthews, your lordship will recall, is the Chief Director, Inspectorate, Immigration Services in the Department of Home Affairs. He says, I'm advised that as a matter of international law, an agreement was reached between the Tanzanian authorities and the South African High Commission regarding the deportation, in accordance with international protocols. He tells the court an agreement was reached. And then, to just nail that down, Ms. Nao Teresa Moran, her affidavit is found at 207, and on page 210, paragraph 13, she says the following. The agreement in deportations, there's no agreement between states. Just read to you from the Constitutional Court. Agreement is extradition. And then she goes further. The agreement between the Tanzanian authorities and the High Commission, and the court will recall it well, she is the 3rd Secretary, I think it is.
Yes.
In the employment,
yes, 3rd Secretary.
And the High Commission to deport the applicant back to South Africa was reached at the premises of the High Commission. So on the High Commission's premises in Tanzania, there was an agreement reached to deport the applicant. And then she says, I'm advised that once that happened, once the agreement was reached, as a matter of international law, was regarded to have been in the custody of the High Commission on South African soil.
Does a deportation means that you are deported to a specific country?
I've just read to your Lordship, and perhaps I should read it again, paragraph 28 of Muhammad. Deportation is, this is on 136 of the bundle. Deportation is essentially a unilateral act of the deporting state in order to get rid of the undesired alien. The purpose of deportation is achieved when the alien leaves the deporting state's territory. An important sentence which answers your Lordship's question direct. The destination of the deportee is irrelevant for the purpose of deportation. It's irrelevant. It's destination neutral. As long as there's a, let's call it a kicking out, deportation is achieved. There can be no question of agreement to deport to a particular destination. Once that language is in the respondent's answering affidavit, it's the end of the case. So we would submit, my Lord, this is part of my introduction, I've diverted someone, but we would submit that's clearly one law. But also, even if it is sourced in law, it can't be a stratagem, it can't be for an ulterior purpose. What else was this? This was clearly a stratagem to achieve a result for particular purposes, ulterior purpose. So we would submit that on any basis, international or otherwise, this falls foul of the Constitution and the law. Now, Lord, let me go to the second chapter because it's not unimportant. I've debated this with my colleagues, and they agree with the point, but they're not sure how it fits into the big scheme. And I'll let me answer how I understand the point fits into the big scheme. If your Lordship is not with us on this grand idea of this was a disguised extradition, why disguised extradition, then your Lordship will have to consider the following. On what basis were the police, on what basis were Home Affairs in Tanzania, what were they doing there, and where did they get their authority from? And it's a strange answer that your Lordship will find. And this was the answer from Home Affairs is found because my attorneys had written a letter to say, what was the Home Affairs authority? They were there. They insisted on joining this case. Home Affairs insist. Why were they there? And Mr. Matthews tells the court why he was there. But why? He tells the court the basis upon which he was in Tanzania. On page 169 of the record, Mr. Matthews, under heading, says deportation of the applicant. And he has a whole series of paragraphs which explain. He starts off by saying on the 12th of April he was advised by the DG that he'd received a telephone call from the South African High Commission in Dar es Salaam that the Tanzanian authorities had issued notices declaring the applicant and investor as prohibited. And then the important point, my Lord, liable to be deported back, and I suppose there's a typo, to South Africa. It doesn't work that way. I've explained, the Constitutional Court has said, you don't get to be liable to be deported back to some place. You're liable to be deported, which means out you go. You can't be deported to somewhere. It's just, that's not the law. In terms of the Tanzanian immigration laws, and the Tanzanian immigration laws, they attach the particular section 25, and your Lordship knows our argument that even under the Tanzanian laws, which your Lordship doesn't have to go there, the applicant was not deported lawfully in terms of their law. But you don't have to go there. Not for your Lordship to consider that. So then
what does the, sorry Mr. Katzel, what does the notice says that the notice of deportation, if I can call it as such, it mentioned that she must be out of Tanzania in 3 days' time. But did it say that she must be taken back to South Africa?
No. Doesn't say that at all. It said it's on page 202. The only time the word South Africa is mentioned is the nationality of the applicant and the place of issue of the passport. No destination mentioned on the provisional. So that's why I say, when Mr. Matthews tells you what he does here in paragraph 18 on page 169, it's not true. He says he got a phone call. I don't know, well, I can't speak for the phone call from the High Commission to him. But what I can say is whatever, if the High Commissioner told him what he said here, then the High Commissioner cannot be liable to be deported back home. And the notice doesn't say that. But let me just go on, my lord. In terms of the notice, this is paragraph 19, the applicant was declared a prohibited immigrant, etc., and then there's references to sections of the Tanzanian immigration law. And then, in 20, the DHA, Department of Home Affairs, was required to provide air transportation for the deportation, and it was decided that, importantly, my lord, and this is his words, their handover. No handover in deportation. Handover is a concept essentially in extradition matters. Will be done in terms of the immigration laws, the Vienna Convention of Diplomatic Relations and International Protocols. And I just want to drill down into the next 3 paragraphs. Well, this is the second point of my chapter on the question of the unlawfulness question. That's even if your lordship rejects the question of disguised extradition as stratagem, in any event, they acted unlawfully on their version. So what happens then on paragraph 21? They say on the same day, on the instruction of the 12th of April, the instruction of the DG, the DHA hired a private aircraft as requested by the Tanzanian Immigration Division. I took immediate steps. He obtained 3 quotes from the relevant companies, presented to the DG, and then there's the invoices. Then he goes on. In view of the reports that Best orchestrated an audacious prison escape, etc., I decided to enlist the services of a special task force of SAPS. This was not foreign. Leave aside that for a moment. But the important paragraph is the next one, 23. And this is where he tells the court, Mr. Matthews tells the court the power that he relied on, authorization, the section authorizing him to do what he did, by going to Tanzania and doing what he did there. It says, in fact, section 41 of the Immigration Act places the responsibility of performing statutory functions and powers on both the immigration officers and members of SAPS. So his reliance in this case is on section 41. There's no more. He doesn't mention any other section. And we've given section 41 to the court in our heads of argument. But it's just time to turn to the bundle. Because in our bundle, on page 29, and 31, 29, going through to 31, we've got extracts from the Immigration Act. And when I read section 31 to your lordship, you will see it's a nonsense to say that what Mr. Matthews was doing in Tanzania could possibly be regarded as in terms of section 41. And once your lordship comes to that conclusion, then your lordship must find that what Mr. Matthews was doing in Tanzania was unlawful. Leave aside all the fancy disguised extradition stratagems. On his own version, he tells the court, I was relying on a section 41 to do what I did in Tanzania. Your lordship will look at section 41 and see, does it make sense? Is he correct? And your answer is no. Let's see what it says. 41's got 2 parts. 1, when so requested by an immigration officer or a police officer, so he says that in his answering affidavit, any person shall identify himself or herself as a citizen, permanent resident, or foreigner, and if on reasonable grounds such immigration officer or police officer is not satisfied the person is entitled to be in the Republic, such person may be interviewed, etc. And such immigration officer or police officer may take the person into custody without a warrant. What's the section about? It's about when the immigration officer or police officer is walking around the streets of Bloemfontein or wherever and sees someone who looks a bit dodgy from a, that's the word that they use in Cape Town where I'm from. The person looks dodgy from an immigration perspective. He calls the person over and he says, identify yourself. And show me that you've got permission to be in the Republic. That's what Section 41 does. It doesn't allow for Mr. Matthews to jump onto a hired chartered plane, arrive in Tanzania, and go and interview people who may or may not be South Africans. That's not Section 41. But he says he can use 41. Why? Because the agreement that was reached, it's actually laughable, but if it wasn't so sad, it would be laughable. But, so what he says is, he could do it in Tanzania because the South African Commission in Tanzania was South African soil. That's what he says. But he didn't do it especially the South African Commission in Tanzania, I'll turn to this now on that point, is not South African soil. Perhaps, we were consulting last night with one of the people, who's an attorney, said, people have this idea that foreign embassies and missions, consulates, are the soil of the sending state. And he said, I said, no, that's not the law. And he said, maybe he's watched too many movies where you see these people running to the embassy, and they try to get into the embassy. Once they're in the embassy, they're safe from what's going on in that country. It doesn't work that way. That's a movie point. The law is the soil of the mission or the embassy is the soil of the host country, and it remains so. It's not South African. South African law does not apply to the mission. So even if, in some strange world, Mr. Matthews could come along and say, well, I entered South African territory in Tanzania in the mission, which he didn't. And there I looked at the person and I said, please show me your identity. Do you have permission to be in the Republic? Then maybe some strange loop-chained argument could happen. But he's wrong on every single one of those loops. Firstly, this applies to in the Republic, and he certainly wasn't using Section 41 to determine whether the applicant or investor were entitled, these are the words, entitled to be in the Republic. That's just not true. Now turn to this question of South African soil. And before I turn to it, just let me turn to what he says, Mr. Matthews. He says that, and perhaps I should ask your Lordship to turn to page 172 of the record. He says in paragraph 30, he says, these are his words, I'm advised, as a matter of international law, once they hand over to me, so we know the Commissioner, Tanzanians handed it to the Commission handed it to the Commissioner, handed it to him. At Kilimanjaro Airport in Arusha, I'm advised that as a matter of international law, so he tells the court his understanding of international law, his advice on international law. Once the handover to me was completed, the applicant and investor were regarded as being on South African soil. What he says. Now, firstly, it wasn't on the mission's premises. So as a matter of fact, he's just got it completely wrong.
That was on the airport.
At the airport. At a different city. So it's not on the mission. How can that be possibly South African soil? Kilimanjaro Airport in Arusha can never be on South African soil. Just a nonsense. But then he says, therefore he says, it's important to hear what he says, contrary to what applicant's attorney suggests in his letter, it's the letter I mentioned to you, Lordship. He says, I could exercise statutory powers in terms of South African immigration laws, and in this regard, legal argument will be advanced when the matter is heard. The Lordship hasn't seen any written legal argument at this point. But he tells the court that he, Matthews, South African immigration officer, could go to Tanzania, South African immigration laws, because it seems to us that when the handover took place, he was on South African soil. Then, the third secretary makes the same point. She says on page 209, she says, the previous page, she talks about the Vienna Convention on Diplomatic Relations, which South Africa is a party, talks about the premises of the mission being inviolate. But then she says, in simple terms, the premises of the High Commission are regarded as the South African soil, what she says, as the South African soil and property, that of the government of the Republic of South Africa. And attached to her answering affidavit is the Vienna Convention. That's her version. Now, she doesn't say, and she can't, that anything happened on the territory of the mission other than the agreement that was entered into between the Tanzanian authorities and the South African authorities. So that's what she says. Now, let's just analyze as a matter of law. Is it correct that a foreign embassy or mission is indeed territory of the sending state? And for that I'll turn to page 191 of our authorities bundle. May I just interrupt myself, my lord? I'm going to, before I turn to this conclusion on this, Your Lordship, I don't even know if I need to make the point, but South African law doesn't extend beyond the borders of South Africa. Kaunda said, the Constitutional Court made that point in Kaunda. We've given that to Your Lordship in our heads.
Is that on 199? 191.
191.
Yes, thank you.
This is an extract from the textbook. We have a copy of the textbook as a whole, which we could hand up. It's the 5th edition of Dugard's International Law, the South African Perspective. The 5th edition was 2018. We've given a couple of extracts from the book in this bundle, but if Your Lordship would like to, let's call it, borrow the book or have the book.
No, it's okay. Thank you, Mr. Katz.
It's a nice book.
You think I should read the whole book?
Well, read it. I think you should read, perhaps you should read the parts that relate to this case, but I'm going to try to take Your Lordship to the parts.
Yes.
Which is on page 191. The court is dealing with this question of diplomatic missions. And in little a on page 380 of the book, Professor Dugard explained that in order to enable a diplomatic mission to carry out its functions, Article 22 provides that. That's the article that the Third Secretary referred to. Other articles provide that the archives and official correspondence of a mission are inviolable and that a mission may freely communicate with its own government and other missions and consulates of the sending state. Remember, in our case, the sending state is South Africa and the host state is Tanzania. And there's reference to a case concerning United States diplomatic and consular staff in Tehran, which Your Lordship doesn't have in this extract, but it is in the book if Your Lordship changes his mind. But anyway, the point is this. Diplomatic missions use a diplomatic bag to transport diplomatic documents, and then we go down on the page 381. Well, at the top of the page, in recent times there have been a number of instances of serious abuse of diplomatic premises and the diplomatic bag on missions. In 1984, persons inside the Libyan mission in London fired shots at demonstrators outside the mission, killing a policeman. We leave that aside. And at the bottom of the page is the important paragraph for our purpose. B, extraterritoriality of missions. The inviolability of the diplomatic mission led to suggestions, this is because of Article 22 of the Vienna Convention, that it was accorded a special status by the receiving state because it was an extension of the territory of the sending state, that it was extraterritorial. That's what Your Lordship hears from Mr. Matthews and from the Third Secretary. South African soil in the middle of Tanzania. And then he goes on. The explanation for the inviolability of the mission is no longer accepted. And there's a reference to V.J. van der Merwe, 1987, and various other references. A case in England, 1972, and S versus Para, 1986 case. Instead, it is generally accepted that the inviolability of a mission is based on functional necessity, that such inviolability is necessary to enable the mission to perform its functions. And now we come to the kicker, the real end of the debate, for purposes of South African law. This extraterritoriality theory was firmly repudiated by Groskopf J. in Santos v. Santos. There's a reference, 1987 case. When he held that a marriage solemnized in a foreign embassy or consulate by a person, in this case a Portuguese vice consul, who was not a recognized marriage officer under South African law, was invalid. The judge accepted the view of Michael Ackhurst, who's a famous professor of international law, footnote 213, a modern introduction to international law, 1982, that diplomatic preferences are not extraterritorial. Acts occurring there are regarded as taking place on the territory of the receiving state, not that of the sending state. So now I end my chapter 2 by saying section 41 has no place in this case. It's a section that Mr. Matthews relies upon to suggest that he had the power to do whatever he was doing in Tanzania. That's simply wrong. And you've heard no argument, or do not. You haven't read any argument contrary to that. 2, both he and the third secretary explain away all of the difficulties by saying this thing, whatever the thing is, and we'll talk about that thing in a moment, happened on South African soil. Well, it didn't, because South African soil does not exist in the Republic of Tanzania. Number 1. Number 2, whatever the thing is, and the thing can be a number of things, it could be the handover. The handover didn't occur on the mission. It's territory, premises. The agreement that was entered into, it might have happened at the premise of the mission, but so what? So we submit that on those 2 legs, were your lordship to reject the disguised extradition, the Muhammad point, the respondents fail miserably on this question of no power, the Fedsure prerogative point. Section 41 is no cure to their difficulty, and the South African soil problem, Santos v. Santos, and the other cases cited in the Dugard book. So now I turn to my 3rd chapter. And in my 3rd chapter, I'd like to just flick through the facts. Now, your lordship knows that the facts, your lordship, I do not intend to spend time on the applicant's version, because all she says is, she gives a version, the lordship can accept that she's in custody now. That your lordship must accept. You can accept that she says she's in unlawful custody. That your lordship can accept. And they don't disagree with that. How she finds herself in unlawful custody is for what your lordship will look to the respondents to see what they say. So, my lord, there are various aspects, and perhaps I should just start off by telling your lordship there are 3 affidavits from the respondent. One by Brigadier Shibiri. That starts on page 56, 57, and that's on behalf of the 1st, 2nd, and 3rd respondents with a number of confirmatory affidavits. There are many aspects of the affidavit with which we don't have a problem with. Then there's an affidavit from Matthews, and there's the affidavit from the 3rd Secretary on behalf of the 6th respondent. But let me turn to Brigadier Shibiri's affidavit and develop some ideas. On page 62, he has a heading, Admission of Hearsay Evidence. We have no difficulty. Any evidence that he puts up, which he suggests is to be admitted under the Law of Evidence Amendment Act, section 3(1)(c). No difficulty. The lordship can have regard to it. Then he starts off introduction on page 64, and I do wish that the court can flip through it with me, because there's some important development that he suggests. He explains what the applicant's case is, etc. On 6th of April, she was arrested and abducted by SAPS in Tanzania. He denied. Let's accept his denial. Then we go on, and he talks a lot about Pester and the coffins and the exhumation and the escape from prison. It's all very interesting, but nothing to do with this case. And he talks about, importantly, what the DPP wants to do with the applicant. There are provisional charges identified against the fraud, etc. That's on page 67, 68, defeating the ends of justice, etc. Then, on paragraph 35, he explains that he now tells the court that she was arrested at Lanseria Airport by SAPS. So what SAPS does is this. It goes to Tanzania, an eight-member team, I think on the 8th of April, and they have, and importantly, I use this word, deliberations with their counterparts. That's the word that I'm going to come to. He uses the word deliberation. But they take no action. SAPS takes a hands-off approach. We're not touching this. We're not touching with a barge pole. Because we know, and the Tanzanians have told us, we will not give you, we will not hand over anybody to the police, because that could be regarded as a disguised extradition. So SAPS, hands up. We're not party to this. We're just looking and protecting, but we're not party to this handover business. That's what they say. That's the theme of the affidavit. We will read that over and over and over. We were observing. Esther was dangerous, we were protecting. That's the theme. When did SAPS act? The moment they arrived at Lanseria, into the morning of the 13th of April. And they had left just after midnight on the 12th. And your Lordship has already pointed out that the notice to the prohibited immigrant was issued on the 12th, and yet 8 hours later they're being arrested at Lanseria. So they explain all this from paragraph 44 and on. Perhaps it's worth looking at paragraph 46, where he says, an urgent meeting, this is on page 71, was arranged by the SAPS and at the Tshwane Academy in Pretoria, to which Principal was invited. A meeting was made that a multi-department team from South Africa should be assembled to travel to Tanzania to deal with the matter. On to the next page. The delegation consisting of the following officials, and I tell you, the Brigadier, the Lieutenant General Mosikili, he's the Deputy National Commissioner of Police as the head of South African delegates. General Modisi, SAPS Free State. General Van Rooyen, head of SAPS Legal Services. Colonel Mendes, Pretoria Interpol. Somebody from Immigration, Mr. Nishal. Mr. Fulasa from Correctional Services. And he was there because he could identify best because we had personal contact with him at the Correctional Centre here somewhere. And then, importantly, my Lord, somebody from the DPP, the NPA's office, the Deputy Director of Public Prosecution, that advocate Magiba, Maxim Magiba. They boarded a plane on the 9th, they travelled to Arusha. It was the SAPS aeroplane. They arrived very late that night. It was Easter. So they could only interact with the Tanzanians on Monday the 10th. The delegations met at the Tanzanian authority at the hotel where the SAPS delegation was staying, the Kibo Palace Hotel. And then in the various issues which they were informed, we had no difficulty with that. Then they say, and this is important, my Lord, because your Lordship will not believe this, under any circumstance. What they say is, it was made clear during the first meeting that the purpose of the engagement, and your Lordship, I've read to you who was there, was to ascertain the identities of the persons reported to have been arrested by the Tanzanian authorities. Then, so let me stop, my Lord. That was the purpose of the engagement. Now we know that can never be the case. The next day, the Tanzanian authorities sent the fingerprints to South Africa for checking. Mr. Matthews says he went down to section 41 to identify the person. That's what section 41 says. So when the police tell you the purpose of the engagement was to ascertain the identities of the persons, that's just not true. On to the next page. Mr. Harris Oshupeng, an official from the South African High Commission, and Captain Amos Ralekwa, a police attaché, were part of the meetings. No problem. Now, importantly, my lord, the first three words in paragraph 53. During the deliberations. Now, my lord, with respect, this is a court. This is a courtroom. But we can take notice that deliberations mean something. An interaction, and you deliberate. You deliberate what's going to be the outcome of our discussion. That's what a deliberation means. Your Lordship will go into his chambers after hearing argument and you'll deliberate. What should you do with this case? Do you give judgment this way or that way? And if you give judgment that way, what would you say? But then, in this case, it's a bilateral deliberation. On the one side, you've got Tanzanian officials, and on the other side, South African officials, mainly police. And during the deliberations, the South African delegation was asked whether extradition documents had been prepared, or were already being prepared, and were being prepared for the subject. In response, we, the South African police, informed the Tanzanians no extradition process had been initiated because South Africa, and this is important, my lord, South Africa's action would need to be informed by the decision taken by the government of Tanzania on the matter. Now, my lord, with respect, that sentence just flies in the face of every single deportation, extradition doctrine throughout the world and through centuries and centuries. South Africa will decide whether to send an extradition request depending on what Tanzanians tell us. And if the Tanzanians tell us that we'll hand over without extradition, no, we have. If they say we've got to bring an extradition request, we'll bring an extradition request. Well, that's not acceptable on anybody's version, in any country, all over the world. Then they go on. If the decision was that extradition route should be followed, South Africa would initiate the process, as it was imperative to the South Africans that proper process should be followed. Initiating the extradition process without having heard from Tanzania what their position would be counterproductive. That just can't be. But my lord, may I jump? And I'd like your lordship to hold your thumb at this paragraph and read with it what Matthews and the third secretary say. First, on page 172, I've already touched upon this earlier, but this is what happens to the deliberation. The deliberation ends in page 172, paragraph 28. This is what Matthews says. I'm advised that as a matter of international, an agreement was reached. So now the parties deliberate, that the South African police and the Tanzanian counterparts, they deliberate, and they come to an agreement at the end of the deliberation. Those are the words that Matthews puts before the court. An agreement was reached between the South African authorities and the High Commission regarding the deportation. Then the third secretary says the same thing. She goes even deeper on page 210, paragraph 13. She says, the agreement between the Tanzanian authorities and the High Commission, and important words, my lord, we emphasize the following two words. To deport. So there's an agreement to deport. Back to South Africa was reached at the premises of the High Commission. So this way, it's an agreement to deport back to South Africa at the High Commission. 4 elements to this agreement. I'm advised, she says, that once that happened, the applicant and Bester, as a matter of international law, were regarded to have been in the custody of the High Commission on South African soil. Well, look, I'm not sure what I can say about this, because it is so clear that what the police say, together with what Home Affairs says, and the third secretary says, is unlawful on international basis, on the constitutional basis, and as far as the law is concerned. Just on this small little tour that I've taken of 3 paragraphs, an agreement to deport back to South Africa. The agreement was on the High Commission premises, therefore, when that happened, wherever they were, wherever Bester and the applicant were, they were to be regarded, in her words, as to have been in the custody of the High Commission of South Africa. That's just nonsense. Please, with respect. I don't want to be too rude to the Third Secretary, but we have some difficulty with the logic in that. Then, my Lord, I've made this point, that the police tell the court why they went there. That's in paragraph 51. But then one turns to 2 pages later on page 75, where the policeman says, Brigadier said, Bester was positively identified by the DF Correctional Services person, Mr. Paulasa. And then in fact 58, this was followed by sending the fingerprint samples taken by the Tanzanians to South Africa to establish the identities of the 2 people. So we know, how do you identify persons who are arrested overseas? You take their fingerprints, this is what the police tells you, and you send it to South Africa to identify the identities of, to establish the identities of the people. So your Lordship has 2 versions in 3 pages by the police. One, the police were 8 people were in Tanzania to ascertain the identity of the persons reported to have been arrested. That's the one version. That's why they were there, 8 policemen, or 8 people, including mainly policemen, high-level policemen. And the other version, they sent the fingerprints from Tanzania to South Africa. Your Lordship has a choice. Do you believe version 1 of the Brigadier, or believe version 2 of the Brigadier? And then he goes on. Durko offered Bester and the applicant consular services. Both declined. My Lord, let me just deal with an argument now. There is no evidence, no suggestion of evidence, other than a bit of a whisper, that when the applicant was put, she said, good, I can see my children. But when we talk to consent, when we talk to waiver of rights, or waiver of, leave aside liberty rights, but waiver of a right to be extradited, not a word. And what could have happened, but didn't happen, is they could have said to the applicant, look, you're going to be deported, whatever that might mean under Tanzanian law, but we want you back in South Africa. And if you consent to deportation, you're going to be back in South Africa in this strange, unlawful mechanism. Or do you insist on your rights and insist that we bring an extradition application? They didn't do that to her. She had no clue. And I'll tell you why that's important, because in Muhammad, perhaps I should just, and I'm going to turn to it, and 147 of the bundle. And leave aside the death penalty issue. But perhaps I should just read it, because it's not unimportant. I know it's death penalty, but the principle of the state. This is mine. 147 on. There's a heading. Consent to deportation or extradition. And what happened to Mr. Mohammed was, he was a liar. He was in Cape Town on a false visa, asylum visa, liar. He was flipping burgers at Burger King somewhere in Athlone, and he went to renew his asylum visa. He walked into the office, and they said, thank you, Mr. Mohammed, come this way. And they put him in the lift, took him down to the ground floor where the parking was. As one knows, you have parkings. And they said, come this way, and they took him to the car. The next thing is the car was going to the airport. 18 hours later, he was in New York before a grand jury. And the government said he consented to this, whatever it was, extradition, deportation, or whatever it was. And one sees in paragraph 61 on page 147, this is what the government said. A submission strongly advanced on behalf of the government was that Mohammed had consented to his removal to the United States. Whether the removal is characterized as deportation or disguised extradition. And then they say it is open to doubt whether a person in Mohammed's position can validly consent to being removed to a country in order to face criminal charges where his life's in jeopardy. The authorities ought not to be encouraged to obtain consents of such a nature. And then on to the next page, paragraph 63. An indispensable component of consent would be awareness on the part of Muhammad that he could, etc., not be lawfully delivered without obtaining death penalty issues. And then paragraph 64, the onus to prove waiver is on the government. To Blanche and Christians alleged Muhammad freely, if not eagerly, chose to go to New York in the custody of the FBI agent. Muhammad flatly denies this. So direct and one-dimensional a dispute of fact cannot really be resolved in that way. Nor is it possible to ascertain a clear preponderance probability in favour of the government version. And then next paragraph 65. None of the government opponents even suggest that Muhammad was aware of his crucial right to demand, etc. Indeed, there is no suggestion that any of the government officials concerned ever considered this feature, let alone contemplating informed Muhammad. On the contrary, the impression by the affidavit, they were content to let him go, etc. The simple proposition is, on these papers, there's no suggestion that any, open quote, consent by the applicant to be deported back to South Africa in the custody of Mr. Matthews, unlawfully in Tanzania, on the basis of an unlawful section, on the basis of not soil but soil, was communicated to her. She had no clue. Not only did Mr. Matthews have no clue, nor the Secretary have no clue, how could the applicant have a clue about these interesting international concepts? Then, I'll go on in the Brigadier's affidavit. I will try to complete my argument by 11:30, if that's within your lordships. I'm just thinking about tea for lordship.
Yes, now you may proceed, Mr. Krantz. Thank you.
So I was talking at page 76 of the papers, and here the police explain what happened. They continue to say, and then, my lord, interestingly, in 62, the policeman makes the point that the Tanzanian law, that they had ordered the applicant to leave Tanzania within 3 days. So there's no explanation on these papers why she wasn't given 3 days. And the only conclusion that you can come to, my lord, is that the South African had agreed that she wouldn't have those 3 days. There's no other possibility. It just doesn't make sense. Then in 63, I have to read that the delegation was informed that in dealing with deportation, as a Tanzania hands deportation to the embassy, South Africa has been ascertained as the country of origin, Tanzania, which would hand them to the South African so they could be removed. Now, my lord, that is not deportation under any international concept, and we've given you the cases. It was decided that they were to be handed to South African diplomats. It doesn't say who decided it. The normal process would require the South African High Commission to engage. Look, I've been doing this kind of law for 30 years. And they say the normal process of deportation would require the South African High Commission to engage the DHA's immigration section. Never heard of that. The first time I've ever seen anything even resembling this normal process. The normal process is you say to the person, all over the world, leave within 3 days. And if after 3 days they don't leave, you may arrest them and you might contact whichever embassy it is and say, listen, we've got your national, they won't leave, please come and collect them. But this normal process would require the South African High Commission to engage South African immigration. It's the first time, and I've done this to every court in this land, in many countries around the world, in Europe and Africa, I've never seen anything like this. The third secretary then travelled from Dar es Salaam to to attend the consulate relating to the matter. And then importantly, my lord, they know they're in trouble. So what they say is, Advocate Makiba, that's the NPA person, participation in the engagement as an NPA official was limited to ensuring that the event of the personal identity were confirmed and they were returned, the state would be able to prosecute them should that be necessary. What does that mean, my lord? And I'll ask your lordship, what does it mean that you have an NPA official, he's the deputy director of in Pretoria, who goes there to Tanzania, part of his delegation? Why? To ensure that if they were identities were confirmed and they were returned, the state would be able to prosecute them should that be necessary. It doesn't make sense. With respect, logic dictates that this can't be true. He was there to consider how to extradite them back. That's his job. That's what they say his job is. And to assist in that context. Then in 66.1, the South African officials would visit the place where they were held. He would not be, the Advocate Makiba would not be part of the exercise. And then when they're handing over by Tanzania to immigration, now they say to immigration, not to the High Commission, to immigration, as then he wasn't present. So now they recognize they have a problem because they have this loose cannon of the NPA hanging around to try to make sure that we can bring them back, prosecute them. This loose cannon is pushed to the side. They made sure he was not present. What was he doing in Tanzania? Then, the DHA plan landed late in the evening of, this is paragraph 70. The applicant investor were handed over to the South African High Commission, not immigration as previously said, but there's another, again, different version. And my lord, the plane left, paragraph 75, left Tanzania at 00:23, 23 minutes past midnight. And now our learned friend distanced himself from what happened. Throughout, this is the important sentence, my lord, that they say, throughout this whole process, the SAPS only provided protection and security service to the Home Affairs officials aboard that plane. So, and that's the theme. SAPS stood back. We, the police, we don't get involved in this. It's Home Affairs business. The Lordship will decide whether that's true or not. And it landed at Lanseria. The SAPS team, which was investigating the case, arrested them. The Lordship knows that in 71. So, my lord, in paragraph 78.14, sorry, my lord, 78.10. Let me just jump back the page on page 82. The applicant was never arrested, as stated, nor was she handcuffed at any point before or during the flight from Tanzania and then the rider, by the SAPS. By the SAPS. This entire affidavit by the Brigadier is to absolve SAPS from any responsibility whatsoever. They've got a hands-off approach. They didn't do it. It does nie mate in woorde pay. Wasn't in my presence, therefore it didn't happen. My pro-deo days, I remember those are the words. The witnesses, those policemen. Nie mate in woorde. Torture, nie mate in woorde. The applicant is being unduly, utterly, etc. Paragraph 78.14. Deportation is a unilateral act of the deporting state. The government of Tanzania was within its rights to deport in accordance with its law. In this instance, South Africa was preliminarily engaged to ascertain the country of origin. The process was purely a deportation. Agreement back to South Africa, etc., etc., that just can't be believed. And I turn to Matthew's affidavit. I just want to push through. He says he's the chief director. Your Lordship knows that. That's on page 164, 5. And he goes on where he explains the deportation. Paragraph, on page 169 in paragraph 18, he explains what happened on the 12th of April. I've already made the point that in the second last sentence, or second last line of that paragraph, liable to be deported back to South Africa. Now, I've got written here a big no. Down the page, paragraph 20, DHA was required to provide airport transportation for the deportation as it was decided that their handover will be done in line with it. Who decided it? They don't say. In the air, it was decided. 21. On the same day, I read this to you already, my lord, about the plane. I read to you paragraph 23, section 41, and then on page 172, what we would suggest is the serious difficulty for the respondent. I do want to turn to some legal points and then turn to the remedies. Some legal points are, and perhaps I should do it, the best way to do it should be through our heads of argument. It was a lot of paper, and perhaps I should just flip through our heads and talk to the various chapters that we speak of with reference to the budget. We start off by saying in paragraph 3, perhaps I should just make a note here. In paragraph 2.3 of our heads, there is a reference to a document, a media statement. I'm not sure, but it may be one of those documents that the sixth respondent wishes to have struck out. But we submit, my lord, that your lordship will consider the document in the context of the facts as a whole and decide whether strikeout's appropriate. But I should read you paragraph 2.3 because we say the sixth respondent accepts, I've read this to you already, my lord, an agreement between the Tanzanians and the High Commission regarding the deportation of the applicant. And then we say that government has publicly made it clear that the purpose for the delegation being sent to Tanzania was to negotiate and deliberate the deportation of inter alia the applicant. In a public statement of the government on the return of the doctor, the applicant, it is stated that the high-level delegation led by the department sent to Tanzania on Monday, 9 April, has successfully concluded the deportation of the fugitives. It's a public statement. My lord, we would submit that if your lordship accepts that as what the minister said, or the government said, that supports entirely the case of the applicant. Successfully concluded the deportation of the fugitive. What does that mean? Now, a learned friend might ask, well, this must be struck out. Your lordship doesn't need this in an affidavit. Your lordship can go to the internet. Something your lordship could take judicial notice of with respect. The whole world is watching. The world watches what I say, what your lordship says, what our learned friends say. When the minister stands up in a media statement and says something, and he says, the Department of Home Affairs has successfully concluded the deportation of the fugitives, and our learned friends want that to be struck down. Not appropriate when it comes to striking. And then we explain that, as your lordship pointed out to me earlier, a disguised extradition form of deportation is unlawful under the Constitution, and we talk to Ibrahim. Now, Ibrahim is our true cause of action, the rule of law, which Ibrahim talks to. I don't know if your lordship has an opportunity to even glance at Ibrahim. It is in our bundle.
I did.
As it uses the thing. And then I just want to make the following two propositions in the next three paragraphs. We emphasize that this case does not concern the lawfulness of what Tanzania did in Tanzania. It also does not concern the conduct of the applicant. It concerns an objective constitutional question, that is whether the South African government acted lawfully in being involved in effectively arresting the applicant in Tanzania, and they have to accept it. The Home Affairs say they did it, and forcibly removing and returning her to South Africa following an agreement reached. That's the one proposition. The Constitution regards the conduct of the government as inconsistent with the rule of law, the principle of legality, and the obligation to it. But then in paragraph 5 and 6, we turn to international ideas. In particular, so that, my lord, The International Covenant on Civil and Political Rights is made in reference to it. It's a United Nations treaty. It's a multilateral treaty. 120, more than 120 states are parties. And importantly, South Africa is a party to it. And that covenant, international treaty, has a committee called the Human Rights. It's got, now asked that Your Lordship cross off the word council and write the word committee. It's a typo that fell through the cracks. That's in paragraph 5. Not the Human Rights Council, it's the Human Rights Committee. The treaty sets up a committee, not a council. The council's another body. The committee is consistent, and the committee is almost a quasi-judicial body of experts around the world. They sit and they make decisions on individual cases and generalized cases. But they've consistently held that disguised extradition in the form of deportation results in a denial of justice and a violation of the principle of freedom under the treaty. And then in footnote 10, there are some cases: Casiriaga versus Uruguay, Domukowski versus, and some others versus Georgia, Burgess versus Uruguay, and these are 1970s cases. My Lord, we haven't given you the cases in the bundle, but where you wish to have copies of those cases, we'll email it to your registrar. My attorney will hand the hard copy to your registrar. I don't know whether your Lordship can decide. Let me make the offer, and let me assure your Lordship that by the end of today, my attorney will have provided hard copies to your registrar of those cases referred to in 10.
Thank you.
Then we move on to Horseferry Road, which is the House of Lords case. And we just want to suggest that it is in our bundle. It's quite big sections from it. Perhaps I should just read it. It involves, interestingly, South Africa. Perhaps I should just go there right now. 84, 85, 86 of the bundle. Well, we will see reference to a United States case called United States versus Alvarez in the Shade. If your Lordship sees that, in Horseferry Road. Horseferry Road is ex parte appellant, 1994 House of Lords case. But let me just say what happened with Alvarez in the Shade, and your Lordship will be interested. There are 9 justices of the United States Supreme Court. And Mr. Dr. Alvarez in the Shade was a doctor for the drug people in Mexico, the drug cartels. The DEA, the Drug Enforcement Agency in the United States, went to Mexico, injected him, put him on a plane, and now he was facing trial in the United States. And his argument was, I was abducted, or whatever it was, you, criminal court, don't have jurisdiction because of this rendition, abduction, whatever you might call it. The United States Supreme Court said, 6 judges said, you do have jurisdiction. Doesn't matter how you come here, you're here, we will try you. But 3 said, no. And we will give you, perhaps, let me read that to you now, what the 3 said. That you will find on 102, if you might jump ahead, my Lord, I do apologize. That is on 102, you will see what the 3 said. It was actually very interesting when we think of South Africa's history, including apartheid, etc. What the 3s, and I'll give them the set, for where the particular paragraph relating to South Africa occurred. Apologies. But here it is, on page 121. So this is the dissent, the 3 say in 1992. The significance of this court's precedence is illustrated by a recent decision of the Court of Appeal of the Republic of South Africa, that's the appellate division, based largely on its, that the South African Court's appellate division, understanding of the import of this court's cases, the earlier cases, Kerr, etc. That court, the South African Court, held that the prosecution of a defendant kidnapped by agents in another country must be dismissed. The Court of Appeal of South Africa, and now I say the following words, in a constitutional state as we now have, indeed, I suspect most courts throughout the civilized world will be deeply disturbed by the monstrous decision the court announces today. That's the 6. It was the 6 of the court. For every nation that has an interest in preserving the rule of of law is affected directly or indirectly by a decision of this character. As Thomas Paine warned, an avidity to punish is always dangerous to liberty because it leads a nation, Matthews, to stretch, to misinterpret, to misapply even the best of laws. From which it has it here. On the papers, there's a tendency to stretch, soil, Section 41, misinterpret, and to misapply even the best of laws. To counter that tendency, Paine reminds us, he that would make his own liberty secure must guard even his enemy from oppression, for if he violates this duty, he establishes a precedent that will reach to himself. That's what the dissent said. Praising South Africa, praising the appellate division. And now, the appellate division, we go back to 1992. Remember, in Ibrahim, my lord, Mr. Estes Ibrahim, he was tried and convicted and given 20 years in jail for being treasonous because he was a member of the ANC. He became a member of the South African National Assembly after 94 and became a deputy minister, I think, of international relations, as it turned out. The point simply is that I'm not comparing the African to anybody else with Ibrahim. But what I do compare is the rule of law. The law must not be stretched. It must not be misinterpreted, and it must not be misapplied. It must be dealt with, and in the words of Jibbai, strictly and punctiliously. Cross the T's, dot the I's when it comes to the liberty of the individual. Lord, I want to end here before I go to the remedy. On page 150 of our bundle, paragraph 68 of the Constitutional Court judgment in Muhammad. I'd just like to read this and go to the remedy. The Constitutional Court said the following. This is in 2001. Some 23 years ago. And this is what it says. In paragraph 67, we have strongly concluded not been established that any agreement with Muhammad might have expressed, etc., constitutes a valid consent on the one on which the government can place any reliance. The handing over, the words that your lordship sees in this case, on the fact of Muhammad to the United States government for removal by them to the United was unlawful. That's what was found. Then, this is what the court says. That is a serious one. In 2000, South Africa is a young democracy still finding its way to full compliance with the values and ideals enshrined in the Constitution. It is therefore important that the state lead by example. Comply with the law, Mr. Matthews. Brigadier, you lead us. This principle cannot be put better than in the celebrated words of Brandeis and Olmsted versus the United States. In a government of laws, existence of the government will be imperiled if it fails to absorb the law scrupulously. Government is the potent, omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself and invites anarchy. And the Constitutional Court says that warning was given in a distant era, I think it's about 100 years ago, 1928, nearly 100 years ago. It remains as cogent as ever. Indeed, for us in this country, it has a particular relevance. We saw in the past, that's in the apartheid, what happens when the state bends the law to its own ends, and now in the new era of constitutionality, we may be tempted to use questionable measures in the war against crime. The lesson becomes particularly important when dealing with those who aim to destroy the system, terrorism, etc. And then they go on. Here, South African government agents acted inconsistently with the Constitution, with the death penalty point, and then the last sentence. They also acted inconsistently with statute in unduly accelerating deportation and then dispatching the man to a country which they are not authorized to send. And I turn to the remedy. The remedy chapter of our case is contained in chapter 5. which is on paragraph 86. Now there is somewhat of a muted complaint by the respondents that the relief changed and didn't. Nothing can be further from the truth. The relief that we seek is consistent with that which we've come to court for. But to the extent that your lordship scratches his head and thinks, well, this is a serious constitutional matter. I, applicant, have made serious, we as a group have made serious charges and submissions concerning what happened here. You feel that you would wish to make your own tweaks or amendments to the relief. The lordship is welcome to do so on the strength of the Moederklip judgment. And that says that where a claimant in such circumstances should not necessarily be bound to the formulation of the relief originally sought or the manner in which it was presented or argued. And that's what that's Harris J. affirmed by the Constitutional Court. Not the Constitutional Court's reference is not here. That's not important. So now we turn to what should the remedy be. Now your lordship, clearly when it comes to the liberty of individual, is considering a constitutional matter within your lordship's power. That gives you the remedies set out, gives you and obliges you to the remedies in 172(1) of the Constitution. And 172(1) has two substrands. One is A and the second is B. A tells the court that you must, there's no discretion, you must declare conduct or law, this is conduct in this case, there's no law involved here, that is inconsistent with the Constitution invalid. That your lordship will see in paragraph 88. You have an obligation to do so. Then, under B, whether you make a declaration or not, you will always have a wide discretion under B to make any order that is just and equitable. So what we've done is we've crafted what we believe to be the order that you must make, the A order, and we've given you the B order, which is along the lines of that contained in the original notice of motion. And that is contained in paragraph 90, where we say in paragraph 1, the urgency prayer that your lordship sees every day in these courts, and we say that there can be no doubt that this matter is one of serious urgency. And we are concerned that the government tries to swat this away by an urgency point. It's not appropriate in a case like this. But your lordship will have something to say. 2, this is the 172(1)(a), perhaps your lordship could make a note. It is declared, so it's a declarator, that the applicant's apprehension and arrest in Tanzania by officials of the 2nd and 6th respondents, as well as the subsequent forced return to the Republic, is inconsistent with the Constitution of the Republic of South Africa, 1996, unlawful and invalid. Now, were your lordship to come to the conclusion that it's not just the 2nd and 6th, that it was certainly not the 1st, could be a particular person, we submit that it's the 2nd and the 6th, which is the Minister of Police and the Minister of Home Affairs. They come to court, they tell you what's happened. We would submit that would be the appropriate order. 3, this is the just and equitable order that we would, these 3, that's 3, 4, and 5, are the just and equitable orders along the lines of Ibrahim, with the Constitution backing it up. It is declared that applicants, there should be applicants, and I ask that your lordship include an apostrophe and an S. Apologize for that. In paragraph 3, applicant's arraignment in the proceedings under the case number 20 capital A stroke 113 stroke 23 before the 4th respondent is inconsistent, unlawful, and void. Then the warrants issued by the 4th respondent in respect of the applicant are inconsistent with the Constitution, unlawful, and that she be discharged from detention immediately. That's the 5th prayer. And we only ask for costs, including the cost of 2 counsel against the 1st, 2nd, 3rd, and 6th respondents, jointly and severally, one paying the other to And we would submit, my Lord, that these 6 prayers are the appropriate prayers that should be granted on the basis of the facts set out by the respondents. So please.
Thank you, Mr. Katz. I see it is now 20 minutes to 12. Mr. Stellenberg, you will have the floor next, but I think it is appropriate, it would be appropriate if we take a convenience break for 20 minutes. And then we will resume again at 12 o'clock. The court now adjourns.
Here we court the SCA held that a person can also acquiesce. So it's not necessary for express consent. In this matter, there was actually red irons that were put on the person who later became the accused person, but it was only a precautionary measure that was found by the court to be so. He acquiesced to return with the police, and he was then taken to East London where he was arrested. SCA says there's nothing wrong with it. What is also important with regards to this matter is that the SCA, and this has not been overruled, this is the law. There was no duty on Captain McLaren in this matter to explain to him the exact nature and details of extradition proceedings in terms of Clause 5 of the Extradition Treaty. It says the police were not under any obligation to do so. This is still the law. We'll just refer you also to this is Mabena. That's one of the we report held where the removal was not by force of deception, without knowledge, and not without knowledge of a government. It would be quite capable of being reported as retained jurisdiction. It's not, it doesn't fall within the category of abductions that Ibrahim is concerned with. Then just you were referred to the matter of Muhammad by our learned colleague. That's the Constitutional Court judgment, where the person was handed over to the FBI. With regards to the discussion and the consent to deportation or extradition, each case on its own merits. When my Lord reads this case, my Lord will see that one of the big issues in this matter was that Mr. Muhammad was released and taken to a country that had the death penalty, which the Crown Court obviously had justifiably had a problem with. What they do say in this passage you were not referred to, at paragraph 62, the court says this is now under the heading consent to deportation or extradition. It's open to doubt whether a person in Muhammad's position can validly consent to being removed to a country in order to face criminal charge where his life is in jeopardy. So there is already a distinguishing factor. The authorities ought not to be encouraged to obtain consents of such a nature. We did not have a benefit of full argument on this issue, and it would accordingly be unwise to express a view on it. We will, with our side, assume in favour of respondents that a proper consent of such a nature would be enforceable against Muhammad. So the Concord distinguishes this. It says, I don't think a person can consent to be taken to a country where he will be facing the death penalty. That is a very important distinguishing feature of this case that you have not been made aware of. It is so, the court deals with waiver in that matter later, but there is another point that of this case that's of importance, and that you'll find at paragraph 66, my Lord. The judge remarks the following. It says, in the second place, there is a profoundly disturbing circumstance that, on the government's own showing, Muhammad was at no time afforded the benefit of consulting a lawyer. Muhammad was in a very serious predicament is self-evident. Indeed, for him, it was a matter of life and death. In this matter, consular services, including legal services, were offered to the applicant and she rejected it. She did not accept it. So it's rich for the applicant to come to court on motion and then to argue assumptions and to speculate with regards to matters. But she was afforded an opportunity to make use of consular services to get legal advice. She didn't want to. This accords once more, my lord, when we read the papers, with the wish of a mother, detained in a foreign country, given 3 days to board a ship or an aircraft, leave the borders of that country, to acquiesce, to get on a plane, to come back to South Africa. There is nothing in the papers, respect my lord, that justifies the court to reject that version. None whatsoever. There are speculations, but there is nothing in the papers that justifies you to conclude that the version of the respondents whom I represent is palpably untrue and must be rejected there on the papers. None. The applicant's conduct here is wholly consistent with somebody that acquiesced of her own accord, got on that plane and came back to South Africa, and then somewhere along the line, this brilliant idea came to bring this up. It has also not been shown, established by any semblance, that the South African police services made themselves guilty of any untoward or unlawful conduct. Whether the applicant likes the answer is not the question. They don't need to like the answer. But the version as proffered by the first to third respondents is credible. It's not palpably untrue. It doesn't stand to be rejected. There's nothing untoward with governments and the delegation of South Africa going to Tanzania in light of the hype of this matter, the sensational escape of Mr. Bester from prison. He remains a very dangerous criminal. We should not forget that. But when we sanitize our papers and we just leave him aside, when we lose sight of the context of which these matters occur. The delegation didn't go to Tanzania just because the applicant was there. They went to Tanzania because she was with Mr. Bester and another person. And we know what Mr. Bester did. So, my lord, the short and the long of this matter is that the applicant has not argued her own case. She argues a case that she did not call on the respondents to answer today. And she tries to do that on the respondent's case, but she selectively relies on passages in an affidavit, and she asks the court to read things in that isn't there. But we don't read an affidavit like that. We read it in its context. And we read it, we don't take paragraphs in isolation. And when we look at everything, then what happened here is actually quite simple. We know what happened. She wanted to come out, she came. Unfortunately for her, she was arrested after she was entered legally into the country, and she's now obviously incarcerated and awaiting trial. She's applied for bail, and that is unfortunately the consequences of the matter. It's dealt in the papers of the charges, at this stage the provisional charges that she faces. Well, if the applicant survives urgency, which we respectfully submit she can't, and on some level, while she has not made a case for it, the court finds that there is a case in terms whereof her arrest was not in South Africa but in Tanzania, and that was unlawful. We would just like to address you on the just and equitable part of the matter. But I do so, my Lord, with a firm belief that this matter should never reach this stage. Section 172(1) B of the Constitution says that the court which declares conduct unconstitutional and invalid may make an order which is just and equitable. Now, it settled the court has remedial powers under that section. It's very, very wide. It's especially not curbed or limited by the Constitution. The leading case with regards to that is the State Information Technology Agency, SOC matter versus GMA. That's 2018 volume 2. If you are happy, we'll just hand up the note afterwards, just with the case for references. So you don't have to go and look for it.
Thank you.
The court said the following in that matter, at paragraph 53, it said under section 171(1) B of the Constitution, the court deciding a constitutional matter has a wide remedial power, is empowered to make any order that is just and equitable. So wide is that power that it is bounded only by considerations of justice and equity. Now, the consequential orders which the applicant seeks, that's now after the first group, remember, the first group relates to an invalidity declaration with regards to the rest. That's condemnation. The second order is declaring the applicants apprehension, arrest, and abduction in Tanzania on about 7 April, which is wrong. Subsequent transportation to the Republic of South Africa and purported arrest and detention to be declared wrongful and unlawful. Then it goes on and says declaring the arraignment before the fourth respondent under the case, case number 20, capital A, 1133, nullity, and setting aside proceedings. And setting aside all warrants and orders. And declaring the applicant entitled to be discharged from detention and immediate direction of the court to immediately discharged. Now, with regards to that, declaration of invalidity, if that should be made, we respectfully submit that the court should take into consideration the following. The Abraham speak constitutional. The Abraham followed on appeal after the person was arraigned and tried in the court, so he was already convicted. The court then found there was no jurisdiction to do so. We say with respect, my Lord, that the relief that the applicant seeks is not just and equitable. Firstly, the effect of those orders are to divest the magistrates court of its constitutionally statutorily ordained jurisdiction. Which is founded in section 170 of the Constitution, as you know, and grants the power to decide any matter determined by an act of Parliament. We know the Magistrates' Court Act is a creature of that. And you can also have a look at sections 89 and 90 of the Magistrates' Court Act with regards to the substantive and territorial criminal jurisdiction of that court. But it basically provides for offence in respect of district and regional magistrates courts where they have jurisdiction in section 94 areas. Now, the jurisdiction in this matter is a matter of law, it's not of discretion, as was established by the Supreme Court of Appeal in Frank Fuklongo and others. This is Trafina Mukwena and others. I'm just going to read paragraph 19 to you, my Lord. Jurisdiction is a matter of law and not of discretion or equity. What section 173 and 34 are concerned with. In the present case, jurisdiction is governed by section 21 of the Superior Courts Act, which regulates jurisdiction of various divisions of the High Court over persons in relation to matters. Thus, whether the court has jurisdiction or not is determined with reference to that section only. It has jurisdiction, that is the end of the inquiry. The court does not need either section 173 or 34 to justify exercising it. Similarly, the court does not have jurisdiction, the inquiry also ends it. If, on the basis of Abraham, the court finds that the declaration should be made and that you should consider the other relief that he sought. Then we respectfully just ask you to bear in mind the following. The circumstances under which the applicant was brought to South Africa cannot be altered. You don't have a situation that we have at common law with spoliation, where the court says you took possession of an item that you should not have taken possession of because the other person had control or possession of it. Return it, and then you can come to me and I'll afford you substantial relief. But first return it. Make good. The applicant can't go back to Tanzania. She's prohibited. They don't want her. Is the Magistrates Court then irremediably and forever starved of jurisdiction because the applicant doesn't address this issue? What is the effect and the consequences of relief, she asks? The answer should be in the negative. Would it be in accordance of justice, seeing that you will be faced at this legal inquiry if it becomes relevant with what is equitable and just? Would it be in accordance with justice and equity to nullify the proceedings thus far before the Magistrates Court in our post-constitutional era? The prosecution of the applicant in the Magistrates Court is based on evidence which the National Prosecuting Authority has at its disposal against the applicant. The evidence is unaffected, my Lord, with the manner in which the applicant was brought to court. What effect will the consequential orders here have, and will they not unduly interfere with the NPA's constitutional obligations that it must carry out? We understand the dictum in Abraham, but these issues were not addressed in Abraham, and it has never been addressed by any other court faced with this situation post-constitution. The applicant does not complain in her papers. He does not challenge the NPA's decision to prosecute it. So the mere fact that the individual has been arrested unlawfully, does that mean that the prosecution is now likewise unlawful? We know that the SCA has held in the past that even where the machinery of prosecution was found to have been used for an improper motive, that did not necessarily follow that the prosecution should be discontinued. There we refer you to Zuma versus Democratic Alliance and others, and the Acting National Director of Public Prosecution there. The SCA held the view that even in those circumstances, the prosecution of an individual is permissible for as long as there is a reasonable and probable cause for the prosecution. But these are matters that needs to be taken into consideration. The manner in which the applicant was deported, if that is defined, subsequently arrested, will not cause the trial. There's no trial-related prejudice. The applicant certainly did not make such a case. And she also doesn't say that she will not receive a fair hearing from the Magistrates Court. The proceedings in this matter, my Lord, does not only affect the applicant and the state. It affects the victims. It affects the victims you'll see when you read with what the charges against her is. People that are entitled to see justice done. These interests have not been addressed by the applicant, but we respectfully submit are of the utmost importance and should be taken into account before an order can be made as sought by the applicant. So the interests of victims of the offences for which the applicant will be charged, as well as the interests of the public to see justice done, are competing interests. Those interests, we respectfully submit, weigh very heavily against the relief other than the declaration of invalidity. We respectfully submit, my Lord, that you will take that into consideration. Lord, so in conclusion, the fact that there is an onus when a person relies on the fact that he has been denied of his liberty does not mean that the foundational values that govern motions fall away. They do not. One very important value in this matter is, as expressed in Selatsani, that the respondent is called upon to meet a case. We cannot have a situation in law where the respondent not only meets the case, but he refutes the allegations, and then the matter morphs and permeates, and suddenly the respondent must, in argument now, canvass arguments that were never even raised by the applicant in the founding papers. It's ambush, it's litigation by ambush, and it's not how our motions work. In this matter, we respectfully submit that there is no evidence whatsoever that the South African Police Service or the NDPP made themselves guilty of any wrongful or unlawful conduct as explained of by the applicant. She, at the very worst, for the first to the third respondent, acquiesced in getting on that flight because she wanted to come home to her children, which we can all understand. That, my lord, is the short and the long of this matter. We respectfully submit, if you strike the matter from a role, you should do so with cost attendant upon the employment of two counsel who is so employed. The same should follow if you dismiss this application.
Thank you, Mr. Snow.
May I just take an instruction?
Yes, by all means.
Just two short points, if you will allow me.
Yes, yes.
The first is just that there's no proof that there was ever a request for deportation made by the South African government. Just a point that needs to be made. The second is that relief claimed in the notice of motion is against this, and the case is against police, but the applicant an argument challenges the conduct of Home Affairs. You should just take note of that. May it please you, Lord.
Thank you, Mr. Zietsman. The fourth and the fifth respondents have abided by the decision of the court, so they're not opposing. Means that your client and yourself, the Minister of Home Affairs, is next as far as argument is concerned. But I notice it is 3 minutes away from lunchtime. Would it suit you if we stand down till 2 o'clock to hear your argument? Any objections? Thank you, gentlemen. The court will then stand down till 2 o'clock.
Now, we have in our heads of argument, and I'm going to try not to belabor these points because they have been addressed by my learned colleague, Mr. Snellenberg. The fact that the application initially in the founding affidavit was couched as one of the arrest and abduction of the applicant by members of the South African Police Force. But subsequent to that, the application has now morphed to one, as we understand it, of an extradition which is disguised as a deportation. And in paragraph 5.2 of our heads of argument, we deal with the processes and the actions of the Department of Home Affairs. Now, it is important to start off by saying that the applicant and Bester was arrested by Tanzanian authorities and declared by them cannot be disputed. And the reason why it cannot be disputed is because the applicant never made out a case that she was arrested by Tanzanian officials. Her case is it was the South African police force. But what is more, and I think that would put an end to the argument that she was arrested by the South African police force, is the notice at Annexure DHA 7C, which your Lordship will find at page 204. And this is a document from the United Republic of Tanzania, the Ministry of Home Affairs, the Immigration Department. And I'm not going to emphasize this again, but remember, the applicant doesn't take any dispute with what the Tanzanian government did. And in the notice issued, they say in paragraph 2, the above mentioned people, with reference to Besta and the applicant, who were found and arrested in the United Republic of Tanzania for unlawful entry and present with the country, the act which is contrary to the immigration laws. So there they declare, Tanzania declared, we have arrested. And they also declare the reasons why they've arrested. And obviously the fact that they remain detained by them. We then, in paragraph 5.2.2, refer to the notice of prohibited immigrant status. Now, your Lordship will find that in paragraph, page 202. It's Annexure DHA 7A.
Page?
This is the notice.
Page? Just repeat that.
Page 202.
Thank you.
Now, the notice makes it plain, and this is the notice of the 12th of April. It says the following with reference to the applicant. You are unlawfully present within the United Republic of Tanzania. And then paragraph 4 thereof, you are hereby ordered to leave Tanzania within 3 days by escort. Now the importance of that is, it's not by your free will. Remember, this is not a notice by the applicant herself. This is a notice by the Tanzanian government, who clearly indicates that you will leave the country within 3 days through escort. You then refer to section 25(2)(c) of the Tanzanian Immigration Act, and that act provides that where a person has been declared a prohibited immigrant, as we've seen, has been arrested by Tanzania, as we've seen, she may be placed in custody, that happened, until he or she boards a ship or aircraft or obtains any other means of transport conveying him to any place outside Tanzania. The purpose of 25(2)(c) is that it's not necessarily that an illegal immigrant in Tanzania will be brought before a magistrate, but they may be deported and, importantly, remain in custody. Well, if you remain in custody, it's not your choice as to where you go until you board that ship or aircraft. So then we refer in paragraph 5.2.4 of the heads that the department was requested to provide air transportation for the deportation of the applicant and Besta, and that your Lordship will find at page 169, paragraph 20. Now, if we can turn there, this is the affidavit of Matthews. And he says in paragraph 20, the DHA was required to provide air transportation for the deportation of the applicant and Besta, and it was decided that their handover by Tanzanian immigration officers to the South African High Commission will be done in line with Tanzanian immigration laws, the Vienna Convention, and international protocols. Lord, if you turn to the affidavit of wrong. This is on page 207. This is the third secretary in the employ of the High Commissioner. In other words, this is the affidavit of the High Commissioner. The Lordship must start to read from page 208 and in particular paragraph 10, where the High Commissioner says the following. On the 8th of April, the Arusha Tourist Diplomatic Police informed the High Commissioner about the arrest of the applicant and Bester. Then on the 9th, the High Commissioner convened a meeting at the premises of the High Commissioner to discuss the information from the Tanzanian authorities. She decided to send the first secretary, Harris Ochupeng, to Arusha to render consular services, including interviewing the applicant and Bester to verify their nationality. Now this is in line with what the SAPS says. The first plane by them, and on that plane was also a member of the Department of Home Affairs. But it's not the second plane chartered by Home Affairs in this deportation process. Then, paragraph 11, and this is very important within the context of the applicant's argument. It says, on the 11th, Tanzanian authorities informed Ochupeng, or for that matter the High Commissioner, about their decision to declare the applicant investor prohibited immigrants and liable to be deported back to their country of origin, South Africa. Now the very important aspect here is that the decision to deport the applicant back to South Africa, not to any place where she wants to go, but that decision was taken by Tanzanian authorities. And again, to emphasize the point, the applicant does not take issue with that decision. She clearly says, I don't take issue with the actions of the Tanzanian authorities. The High Commissioner goes on in paragraph 12 to say, the declaration issued on the 12th was in terms of section 23(1) of the Immigration Act, which reads as follows, and then it refers to what exactly is an illegal immigrant within the Tanzanian context. So on the 11th, the decision was made by Tanzania to declare them and to deport them back to South Africa. On the 12th, the notice was issued, which I've already referred to Lordship to. Then in 13, she says, the agreement between Tanzanian authorities and the High Commission to deport the applicant investor back to South Africa was reached at the premises of the High Commission. And she then said the following, I'm advised that once this happened, the applicant investor, as a matter of international law, was regarded to be in the custody of the High Commissioner on South African soil. And we see the arguments with reference to section 41 in the Vienna Convention. But just the following paragraph, paragraph 14, because whether a person is in one's custody is a factual question, not a legal conclusion, factually. And just the following paragraph, she says the following. Since they were in Arusha, which is 600 kilometers away, the handover to me by the Tanzanian authorities took place at the airport, Kilimanjaro Airport. In fact, this is normal practice because the Tanzanian authorities had to escort them to the airport to ensure that they have indeed departed the Republic of Tanzania. So they were taken by Tanzania from Arusha, where they were initially arrested. They were brought by them to the airport. Tanzania made sure that there is a handover process at the airport to the High Commissioner, from the High Commissioner to the Department of Home Affairs, in order to be taken back to South Africa. And all of that was to ensure that they are deported back to South Africa. That was a decision not made by South Africa, but a decision made by Tanzania. If you now turn back to the affidavit of Matthews, and you read that in the whole context, then you'll see Matthews says that on the 12th, remember now on the 11th, the High Commissioner knew that they were going to be declared, and that the Tanzanian authority had made the decision to deport them back to South Africa. So on the 12th, the DG in the Department of Home Affairs ordered that transport be arranged, issue notices, the notice that I've already referred to. The transportation was then arranged by the Department of Home Affairs. They say that in paragraph 20, the Department of Home Affairs was required to provide air transportation for the deportation of the African investor, and it was decided that their handover by Tanzanian immigration officers to South African authorities in Tanzania will be done in line with Tanzanian immigration laws. Again, when it comes in line with Tanzanian immigration laws, is their decision in terms of 25 to deport, their decision that you will be escorted, and their decision that you will be deported back to South Africa. So they then go on 21 to explain. They arranged the aircraft, they flew to Tanzania. It was with members of the SSPS as well as correctional services. But obviously, it was a dual purpose in the sense that Bester was also there. And then in paragraph 25, they explain what happened at the airport. Here they say, 25, the applicant investor was transported by the Tanzanian immigration officers and handed over to Moreng, the High Commissioner. A copy of the notice was provided. The notice is DHA 7C, and the applicant was at no stage blindfolded. I think everybody's dealt with that aspect. And they then contend that the DHA acted in terms of the Vienna Convention and Customary International, including the Tanzanian immigration law. Now, if we can just stand still and refer to the handover notice, which Your Lordship will find at DHA 8, which is page 205. Apologies. Page 203, DHA 7B. This is the notice by the South African government, the High Commissioner. It says the Tanzanian immigration authorities have handed South African nationals with reference to Bester and the applicant who were detained for violating the immigration laws of the United Republic of Tanzania to the South African High Commission in Dar es Salaam, Tanzania. The High Commissioner handed them over to the South African immigration officials who were there here to collect the undesirable person who entered the United Republic of Tanzania unlawfully. Now, look, that's the process, that is what happened, as explained by the Department of Home Affairs. What the applicant contends is that it was a disguised deportation, but in real fact, it was an extradition. That's their argument. Now, if we can just stand still for a second and refer Your Lordship to the case of Mohammed. Mohammed is a case relied on heavily by the applicant, and to a certain extent it assists. Firstly, Your Lordship will recall Mohammed was a Tanzanian national arrested in South Africa by our immigration officers involved in the process to arrest and to interview them and so forth. And ultimately, South Africa decided to deport Mohammed to the United States to stand trial there for the bombings of the embassy in Dar es Salaam. And the Constitutional Court was then called to answer various questions. One of them was whether the deportation was valid. And in paragraph 28, they explain the principles or the distinction in general terms between an extradition and a deportation as follows. Extradition involves basically three elements, and we've seen this in here. The acts of the sovereign on the part of the two states, the request by one state to another state for the delivery to it of an alleged criminal, and the delivery of the person requested for the purpose of trial or sentence to the territory of the requesting state. The deportation is essentially a unilateral act of the reporting state in order to get rid of an undesired alien. The purpose of the deportation is achieved when such alien leaves the reporting state's territory. The destination of the deportee is irrelevant to the purpose of deportation. But one of the important distinguishing features between extradition and deportation is therefore the purpose of the state delivery act in question. And that's the state delivering, in this case, Tanzania, and the purpose for which they delivered. Where deportation and extradition coincide in effect, difficulties can arise in practice in determining the true purpose and nature of the act of delivery. What the applicants want your lordship to do is to make a decision as to what the true purpose of the Tanzanian authorities was in deporting the applicant. That, with respect to lordship, cannot do. For two reasons. Firstly, because your lordship doesn't have jurisdiction to do so. But secondly, because the applicants on their own version don't take issue with that. They say this case does not concern the actions of the Tanzanian authority. So just to conclude, Mohammed, the Constitutional Court said in Mohammed, in this particular case, it doesn't really matter whether this was a deportation or an extradition. Because what the court did is it looked at the Aliens Control Act. And that was an act which is applicable to South African home officials. Because, and this is a clear distinction between what we are doing here and what happened in Mohammed. In Mohammed, there was a decision by South African authorities to deport Mohammed to the United States. And the question was whether that was valid. So, in considering the Aliens Control Act, the court referred to Regulation 23 because Section 54, which dealt with deportation, didn't provide an indication whether the deporting state had a decision with regards to which state to deport to. But Regulation 23 said the following, that dealing with the destination of such removals, it reads as follows: any person to be removed from the Republic, this is now South Africa, under the Act, shall, if he or she is the holder of a passport issued by any other country or territory, be removed to that country or territory. And if he's not the holder of such a passport, he shall be deported to where he has residency and so forth, which is not applicable. The important feature in Mohammed is that the United States was not such a country, so therefore the officials of the Department of Home Affairs didn't have authority to decide to deport Mohammed to the United States, and because of that, their actions were unlawful. Your Lordship will find that in paragraph 34. Here, what we have clearly on the papers is a decision by the Tanzanian authorities in terms of their act to deport, and not to deport to anyone, but to deport the applicant who was in possession of a South African passport, although she had 3. One was valid. But to deport her back to South Africa. My Lord, if it stands firm, and we respectfully submit that it should, that the decision was made by Tanzania to deport, that it was going to be through an escort, not what the applicant decides, and that it will be back to South Africa. And the applicant doesn't take issue with any of those. And she can't. It would appear to us that her case boils down to this. The Lordship must find that the deportation was not a true deportation, irrespective of the actions of Tanzania, that there was collusion between the South African government and the Tanzanian government to somehow make this look like a deportation, but it's not. It's an extradition. And in doing so, the argument is that you must solely look at the actions of the South African government, because we are happy with what Tanzania did. But that cannot be. Because if their argument is that an extradition is not a unilateral act like deportation, well then they must take their argument further that the Tanzanian government colluded with South Africa to achieve this. And they don't. So on that score, this whole argument of a disguised deportation we submit cannot succeed. There's a different reason why it cannot succeed. That's just because simply, initially, the applicant made no case out whatsoever that that is the position here, that there was collusion. They jumped on the bandwagon simply because Matthew says there was an agreement to deport in paragraph 13. If you read 13 correct, the agreement was to deport back to South Africa. Now, Lord, we've handed up the 2 agreements. And the argument is simply this: there's nothing sinister about the fact that there's cooperation between the South African Department of Home Affairs and that of the Tanzanian government. The agreement, and I will refer your Lordship to Article 5. It's under the heading Combating Illegal Migration. It says the parties, the 2 governments, shall take measures to combat illegal migration and cooperate with regards to deportation processes and procedures. So, the fact that there was cooperation between the 2 governments doesn't make this a reference to an agreement that we will deport. It doesn't make it a disguised extradition. Now, I informed my learned colleague I will foreshadow the argument probably as to why the agreement is so late. The agreement that I referred to, my Lord, I say again, there was no case made out in founding that the South African government must combat an argument, or if I say the South African government, the Department of Home Affairs, must combat an argument of a disguised extradition or disguised deportation, which is in fact an extradition. So, my Lord, we say, if your Lordship considers this matter, and your Lordship exercise jurisdiction over the actions of the Department of Home Affairs, that, in our submission, is limited to the actions of the 12th and the 13th by chartering a plane where there was a request from Tanzania to support the deportation back to South Africa, to provide the transportation. We submit there's nothing unlawful in that. The cooperation between the governments, there's nothing unlawful in that. And if you properly read the affidavit of Mureng as to what happened at the airport, it was simply the applicant investor was transferred from Aratusa by Tanzania, not by South Africa. They were brought to the airport. There they were handed over to the High Commissioner through the diplomatic relations, and from there to the department who had chartered the plane, so that the decision by the Tanzanian government to deport the applicant back to South Africa can be fulfilled. And they say it in so many words that the Tanzanian authorities were there to make sure that they leave the territory of Tanzania. So on that basis, we submit that the actions of the Department of Home Affairs weren't unlawful. This was not a disguised deportation. The decision to deport, the destination to where the applicant must be deported, was all made by Tanzanian authorities, and that is not attacked. My Lord, we've also prepared the application to strike out. I'm not going to go through the case law that we referred to there, but what we say in paragraph 3.
Before you go there, Mr. Zitzman, you handed me two documents. The one is the agreement with which you have dealt now, Article 5, but there is another one, implementation framework for this agreement. Do you want to refer me to anything in that document?
Look, insofar as the implementation is concerned, it also in Article 5 deals with combating of illegal immigration. It, in essence, is the same as it refers to cooperation between the countries in order to streamline that process and to effect a deportation.
I see. Thank you.
Lord, insofar as the application to strike through is concerned, we refer in paragraph 6 and 7 to the statements in paragraphs 45 to 41, sorry, 35 to 41 of the replying affidavit, where the applicant all of a sudden deals with the media statements by various government authorities. And we say the reason why she does that, or rely on those, is to clearly indicate the intention of the South African officials involved. It's mainly police officials who made statements there. But that, we submit, is new ground, because initially no case has been made out in founding as to why the process was a disguised extradition. And then in paragraph 10 of our aids of argument, or the supplementary aids, we say that the evidence referred to in paragraph 54 of the replying affidavit should also be struck through. This is with reference to the applicant bringing an application in Tanzania. Okay, Lord, share with me a second. instruction to a lawyer, an advocate, someone, to bring an application to declare my detention unlawful, we say there's no evidence in the founding papers. If your lordship read the founding papers, what she says is, I was arrested and abducted by the South African police. There's no mention whatsoever. And insofar as that might be an indication to her bringing an application within the 3-day period, we simply don't know. But we say that that's all new matter that should be struck out of the affidavit. My learned colleague for the applicant has indicated that they don't really take issue with the striking application. I'll leave it at that. Look, there was another argument made by the applicants, and this was with reference to the 3-day period that the applicant alleged here. Now, not only has she not made out any case to say, what I wanted to do within the 3 days afforded to me was to do A, B, C, and D. There's no evidence of that. But let's say she did. Let's, for a moment, just assume that she wanted to bring an application to challenge her arrest, and it can only be, in terms of the 3-day notice, by Tanzanian officials, and her detention by the Tanzanian officials on the basis that she's an illegal immigrant. All of that deals with the interpretation and the lawful actions in terms of Tanzanian law, to which your lordship respectfully doesn't have jurisdiction to entertain that. So that doesn't take the matter further. It's simply a matter to which your lordship doesn't have jurisdiction. Lord, we also stand by the allegations in our heads of arguments insofar as urgency is concerned. My learned colleague, Mr. Snellenberg, has addressed urgency, and I'm really not going to regurgitate those arguments simply by stating that we stand by the allegations insofar as our founding, or sorry, not founding, the heads of argument are concerned. We submit that the application must be dismissed with costs to counsel. Lord, may I just take an instruction?
Yes, you may, certainly. Thank you, Mr. Ziesman. Mr. Katz, I do not know how you want to structure your reply. You informed me in chambers when you came to meet us that Mr. Reinders would deal with the aspect of urgency. I do not know whether you want him to first address the court in reply on the urgency or...
No, I suppose because the argument is developed the way it has, it'd probably be preferable to me to deal with everything.
Thanks.
It's a piece of paper. My Lord, I want to deal with urgency up front and demonstrate that far from the allegations made by our learned friends on urgency on the basis of facts that they put up, the case is far weaker, not just on urgency, but on the pleadings point. So they have complained that we didn't, in our founding papers, put up the notion of disguised extradition, etc., etc. But when one has regard to the annexures to the founding papers, two things will become clear. One is they have played possum, and if they have created the urgency, and two, my client, bearing in mind what the Home Affairs have said, or the DPP has said, not just the police, was perfectly entitled to come to court to deal with it the way she did. May I just hand up an extract from Silver versus Minister of Safety and Security, 1997, Volume 4, Essay 657W. It's an extract, and we put it in our heads of argument to show why the deprivation of liberty must be for no longer than necessary. Every second counts. And I'd just like to read a couple of the paragraphs, because it has a resonance to what happened in far as this case is concerned when it comes to the annexures to the founding papers. Heather J., as he then was in the WLV, 1997, says, "Now it seems to me on the papers before me the applicant has made up what appears to be a prima facie case for the unlawfulness of the brother's detention. Whether that be so or not, the onus is on the respondent, as the Department of Home Affairs, detaining the brother to justify his continued detention. Were this a normal case, that is a matter of some commercial expediency or matter involving something less than the freedom of the individual, I would have no hesitation at all in granting the postponement that has been sought. However, a detained person has an absolute right not to be deprived of his freedom for 1 second longer than necessary by an official who cannot justify the detention. I have by reference to the founding affidavit referred to the attempts, and this is important, my Lord, that were made on Friday, the lack of success that was visited upon the attorney's contacts with the Department of Home Affairs. There are two aspects to this, and I just want to emphasize this when it comes to the letters that I'm going to refer to. From the point of view of the Department of Home Affairs, it seems that if the officials cannot take the necessary steps to deprive a man of his liberty acting within their powers under the Act, as may be, and then place themselves, bona fide no doubt, beyond reach of the administration of justice when they are required to justify that detention. From the side of the police, because now the police were holding the silver person, the police cannot and should not take instructions from another department and detain a person in consequence of those instructions without making absolutely sure they are in a position to justify that detention, and if that justification needs contact with the officials of the other department, that they are in a position to do so. I do not think the liberty of the individual can depend on whether the wheels of state administration run smoothly or not. The liberty of the individual must be sacrosanct in these courts. I don't know when Your Lordship wishes me to hand up the
Yes,
picture.
please, thank you.
Now, may I turn to the letters that were written? So attached to the founding affidavit, there are letters written by Mutlong attorneys to the police and to the DPP. The letters start on page 31. There are 3 letters that Your Lordship will have regard to. On 31, on the 12th of May, Machini Mutlong Incorporated writes to Lieutenant General, National Commissioner of Police. Let me say, there has been no answer to this letter. And this is what he asked for. We hold there's various things about what our client was arrested in Tanzania and brought to South Africa on a privately chartered aircraft. We hold instructions to demand the following: the process and procedure invoked to secure the arrest of our client in Tanzania, the processes leading up to the transportation of our client from Tanzania to South Africa, the details, members of National Commissioner who participated in the operation from the arrest in Tanzania to the transportation of our client to South Africa, certified copies of the applications, etc. Whole list of documents. Then, day before, on 11th of May, Mr. Mutlong writes to the Director of Public Prosecutions, Free State Province. We refer to the above matter. We consulted with our client, taking full instructions. They want the warrant of arrest, and then on the next page, it's page 34, arrest of our client in Tanzania. It is common cause our client was arrested in Tanzania. However, the processes followed in securing the arrest, particularly by the South African law enforcement authorities, including any other parties involved there, should remain elusive. Demand. It is against this background we demand 3.1. The processes and procedures invoked to secure the arrest of our client in Tanzania, certified copies of the applications, including documents to effect such arrest. And the answer to that is given on the next page 36, where the DPP says, page 36, it is unclear what you mean by the type of document, the type of warrant. The warrant was held and handed in court. It is further not clear from your letter under which provision and or legislation the remand is made, or the request or demand is made. Despite the above, it can be mentioned that accused number 4 was arrested by SAPS on 13 April 2023 at Tanzania. She was arrested by the Tanzanian authorities in Tanzania by the Tanzanian authority as being an illegal foreigner. You can contact them if you require more information. The South African police were not involved. That's the answer. So what they say is, we're not telling you. None of the questions of the handover document, the questions of the notice to prohibit immigrant document, not given, despite them having it in their possession, must have had it in their possession, because they were the ones who received it, if not the DPP, certainly, and the Home Affairs, or they could have said Home Affairs had the document. So if we link Silver, the urgency point, not for 1 second longer than necessary, to how certainly the police and the DPP conducted themselves in response to a legitimate request for documentations, we would submit that it leaves much to be decided by those parties. Now, the second point I wish to make is there seems to be a botsing between our learned friends. For the police, it said there was a consent. The Lordship has heard this. S versus December. She wanted to see her children. But from Home Affairs, no consent. The Tanzanians decided how she's going to go. Which is it? Consent? Or was it the Tanzanians who decided on the 11th of April when, how she should leave Tanzania? No question of consent. The Tanzanians decided, end of story. That's the one version. Other version is there was a consent. The Lordship, the respondents can't have it both ways. And we would submit that in and of itself should leave some distaste of the court about government officials playing possum when it comes to the liberty of a person. Then there is the suggestion, the third point that I wish to make, that I have accepted that my client's version is not true and false. I've never said anything of the sort. What I said was this: Your Lordship doesn't have to consider the validity of my client's version, because on the respondent's version, they make out the case. Very different thing to saying, I accept that she wasn't blindfolded, etc., etc. Your Lordship will decide the facts on the basis of the respondent's version, and that version is uncontested. Mr. Matthews acted unlawfully in Tanzania. There's no basis in law for what he was doing there. I've pointed out the Section 41. I've pointed out the soil point. You haven't heard a word, not a word. So Your Lordship must accept, we submit, that there was unlawfulness by South Africa in Tanzania, by the Home Affairs.
Can I just make the remark, Mr. Katz,
yes,
tongue in the cheek, that this is probably the first case in my life that I've heard where the applicant only relies on the respondent's version, while the respondents only rely on the applicant's version. I haven't seen that before.
No, you probably will never will again.
I hope not.
It is unusual. I can't pretend it's not unusual. But that's what happens when you get a respondent who plays possum when it comes to the liberty of an individual when they request. What happened? And the applicant comes to court and gives a version. They reject the version, and now suddenly they come up with their version, which on its face, their version, is bad. If your Lordship goes with our version, I'm not saying your Lordship should reject our version, then of course we win. She was blindfolded and all those kinds of things. Abduction. But I don't need to go there. I can go in both, either version. We win. They say in our version, we can't come home because it's a lie. Not good enough. So that's the second point on that aspect of her version, applicant's version, is that they're correct, both our learned friends, to suggest that your Lordship cannot inquire, these are the words, inquire into or rule on the validity of the conduct of the Tanzanian government in Tanzania. Lordship doesn't have that power, I think. And they rely on a case called Van Zyl versus the Republic of South Africa, it's the Lesotho, South Africa interchange. But what your Lordship can, and we submit must do, is rule on the conduct of South Africa in entering into an agreement with Tanzania. That's the problem. So you have, your Lordship's jurisdiction is limited to the conduct of South Africa, the South African authorities. And if the South African authorities enter into an agreement with a foreign state, the foreign state might or might not be lawful for the foreign state to enter into the agreement. It's irrelevant for your Lordship's purposes. What is relevant is, did South African authorities have the authority to do so? My learned friend forces me to, he's been banging on about this the whole week, and I now have to. He said, on this point, Your Lordship might wish to have regard to page 178 of our bundle, which is a case called the Law Society versus the President of the Republic of South Africa. It's a judgment of the Chief Justice, 2019, Volume 3, Essay 30. Is in our heads of argument quite heavily mentioned. What happened was, there was a SADC tribunal. SADC countries created a tribunal. The tribunal would oversee the SADC countries. And there was something to do with expropriation without compensation of farms in Zimbabwe, and there was a bit of a hiccup as far as South Africa's relations with Zimbabwe went because of this difficulty. So what President Zuma did was, he authored a document which effectively disestablished this tribunal. And the Law Society of South Africa ended up in the Constitutional Court, and said that when the President signed a protocol to take away certain rights to this tribunal, he did so unlawfully. That one sees on page 177, paragraph 72 and follow. At the bottom of the page, in paragraph 75, the Chief Justice says, a proper determination of the constitutionality of the President's conduct requires that several principles be taken into account. First, the Bill of Rights is not only the cornerstone of our democracy, but also binds all arms of the state and applies to all law. And the Lordship will decide the Bill of Rights issue. Was there consent, or was it the Tanzanians deciding what to do with the agreement of South Africans? It's a Bill of Rights problem. Second, the state has a constitutional obligation to protect, respect, promote. Third, and this is the important point for our purposes, we, South Africa, have the duty to honour our international obligations and act consistently with that commitment. And that extends to not undermining or subverting the authority of the tribunal. I'll come back to that in a second, my Lord. Fourth, international that is reconcilable with our Constitution is an essential tool. Fifth, we recognise access to the tribunal. And sixth, the exercise of the power must promote. Now, at the bottom of the page in paragraph 78, and we'll come back to the point that I was going to make about the third and fourth points. But at the bottom of the page in paragraph 78, the obligation to respect, protect, and promote the Bill of Rights includes the right of access to justice that not only find application at a domestic level, it is inseparable from whatsoever is done in the name of the state, regardless of where and with whom. Regardless of where and with whom. So when Home Affairs enter into an agreement, and our learned friends can say, and they're quite right, you look at the affidavit as a whole, and you don't pick and choose in this paragraph, in paragraph 13 of the Third Secretary, you cannot but come to the conclusion, with respect, my Lord, that there was an agreement between the South African side and the Tanzanian side after deliberations. Those are the words. Now, I made this point, my Lord. Third, we have a duty to honour our international obligations and act consistently with that commitment. The first document that we've given you in the bundle, which I haven't mentioned, on page 1, is the SADC Protocol on Extradition. And that's the document that the two states involved could have, and we submit should have relied upon in dealing with this particular applicant. And your Lordship will see, just to complete the picture, that on page 19, on the 3rd of October 2002, done in Luanda, Angola, 3 original texts in English, French, and Portuguese languages. On the right-hand side of the page, one sees Republic of South Africa, and there's President Mbeki's signature. Immediately below that, one sees another signature. So these two states entered into a multilateral treaty in 2002, in which they agreed that there would be certain processes, bearing in mind what is set out on page 4, noting with concern that the escalation of crime at both national and international levels and the increased easy access to free cross-border movement enables offenders to escape arrest, prosecution, conviction. convinced that the speedy integration amongst the state parties, SADC, they seek to create and sustain conditions to eliminate any threat to the security, to make cooperation in the prevention and suppression of crime more effective, bearing in mind the establishment of this treaty will greatly enhance the control of crime, and then they enter into it. And our submission is a simple one. They had this treaty between them. It was a binding treaty between South Africa and Tanzania. They had a good faith obligation, made this in our heads of argument, to comply with that which they had entered into between themselves. Our learned friends don't deal with it. They say, look at the affidavits as a whole. Affidavits as a whole don't mention this at all. So we submit that what happened here was clearly outside the SADC protocol on any level, so that is a problem for our learned friends. Now, I need to turn to December. S versus December and the question of the consent. I ask that your Lordship take into account two aspects, and I'll come to one of the two aspects in a second. The first aspect are the facts of December, and we submit that, well, I'm going to make 3 points. The third one your Lordship might have a smile about, but the first aspect is the question of consent. The appellate division found there was no violence of any sort, and the appellant willingly consented to return with them to East London in order, why? Not to be arrested at Lanseria, between London, to assist them in their further investigation. He was not, so they insist, a suspect because they possessed no information at that stage which incriminated him in any way. And your Lordship will put that comment and you will contrast it with what was the NPA doing in Tanzania. Investigating whether there was a crime, having as in the prosecutorial sense. That's the first aspect. The second aspect is the Lordship will not find, and we submit, on the facts as they are, that the applicant consented, as was done in this case. So there are 4 points. The third point is, it seems to us that December and the rejection of Willem is wholly inconsistent with Ibrahim. It's an aberration. Prior to the Constitution, and it's not appropriate under the Constitution that that type of thinking can be adopted, bearing in mind all the arguments made. The fourth point, I think it's in the bundle, is this. And this is why I said I suggest your Lordship might chuckle, is that in Dugard's book, the comment is made about S versus December, and that your Lordship will find at page 190 of the bundle, where it is criticized. And perhaps I should just read from the two paragraphs, and your Lordship can make on it what you wish. The philosophy expounded in S versus Ibrahim was applied to relations between South Africa, Cisco, and Botswana, which remained nominally independent until 1994.
Okay.
So you've got me, my Lord.
Just a moment. You're reading from 190
of the bundle.
Yes.
It's page 322 of the book.
Yes.
It's an interesting spin on where December comes from, and Mahala as well. So you've got remember the philosophy. It's on the left-hand side of the page.
Yes, I see. Right.
Expounded in S versus Abraham was applied to relations between South Africa, Cisco, and Botswana, which remained nominally independent under South African law until 1994. In Tanzania, it's a case that we rely on Vellum and Base. The failure of the police forces of these territories to respect each other's borders and to follow proper extradition procedures for the rendition of fugitives was condemned and the exercise of jurisdiction refused. In a number of other extraordinary decisions, however, both the lower courts and the AD condoned these cross-border arrests, police deception, and the refusal of the respective police forces of these territories to follow extradition procedures. And then now's the comment I do go. And this is what our learned friends rely on. And we submit it's not appropriate in the post-apartheid the society. He said, this is what Dugard says. The failure, and I have to admit that I'm one of the authors of this chapter, so I nearly came up with it. The failure of courts, including the appellate division in Mahana and December, to accept the collection or apprehension, if not formal arrest, of a fugitive by the South African police in the territory of Ciskei, Botswana, had been a violation of another state's territorial sovereignty and therefore contrary to the fundamental jurisdictional rules proclaimed in the Lotus case. 120, that's the famous case of a ship, which the Lotus was a ship, SS Lotus, and the question was which territory was being. The question was, where could one have enforcement jurisdiction? Leave aside. Can only be explained, my lord, on the grounds that these courts did not actually believe that Ciskei and Botswana were genuine, sovereign, independent states. Let me read that again. Can only be explained on the grounds that these courts did not believe that Ciskei and Botswana were genuine, sovereign, independent states. While it is possible to sympathize with this judicial cynicism about the independence of the homeland states or Bantu states, particularly as the political decision to reincorporate them into South Africa had already been made at the time of the judgment, is it unfortunate that the judges did not fashion a rule premised on the limited sovereignty of Ciskei and Botswana. Instead, we had a number of unreasoned, uninformed decisions which take no account of the basic principles of international law that seek to limit the law and philosophy of S versus Ibrahim. And we would submit, my lord, that your lordship, unfortunately, or however one can, is bound by Ibrahim in the fullest sense of the word. These are aberrations of the law. So what does Ibrahim say?
Just read the one solution is for courts.
Lord, I'm told to read the next sentence. The only solution is for the courts of post-apartheid South Africa to repudiate these decisions as judicial aberrations applicable only to the Bantustan states and not to relationship between South Africa and foreign states. Now, what does Ibrahim actually say? Because we've been talking about it, it's important that we look at what it actually says. And our learned friend for the police, in our view, takes a line and strikes through in holus bolus what it stands for by suggesting that even if, very hard to argue against, even if there was unlawfulness in the removal, that the trial should continue against the applicant. And let me say why. On page 41 of the bundle, the appellate division describes what Ibrahim sought. He said, next to the letter B, on page 562, it is said, or just below B, voordat hy op die aanklagte gepleit het, is 'n aansoek deur hom aangehoor in gevolge in kennisgewing van mosie, waarin die volgende bevelle aangevra is. You see that, my lord? And there were 5 prayers, 4 substantive. Those 4 prayers are the same 4 prayers that we seek today. We've modeled our prayers on the appellate division's prayers, where they describe the prayers that were sought by Mr. Ibrahim in those paragraphs. And then, if one turns to the end of the judgment, and your lordship knows what happened, it's said in the gevolgtrekking, which is the conclusion on page 63, where the High Court, which was Daniel's J, in die uitspraak van die Hof akkoord, het halwe verkeerd. Anyway. And what he said is this, at the bottom of the page, 584I. This is the important proposition that I'm developing on. The appellant's aanbod moes geslaag het. Understand, the appellant's application should have succeeded. Hy was destyds geregtig op die bevelle aangevra in paras 1 tot 4 van die kennisgewing van mosie. He was at that time entitled to the orders that he sought in paragraphs 1 to 4 of the notice of motion. Your lordship will correct me if my Afrikaans isn't accurate.
Yes, no, that's no problem.
My accent might leave something to be desired, but I hope I get the interpretation.
Yes, maybe you can just refer me again to the page that you are.
So I'm on page 584. So page 63 of the bundle.
Yes, thank you.
At the bottom of the page, the appellate division finds that the appellant's aansoek moes geslaag het. The applicants
Isn't that 61? Because my 63.
63, sorry. 63. That's 63 of the bundle, so the bundle, my lord. Of the
Yeah.
bundle of authorities.
Yes, this is what I have here before me. But are you referring to the paginated number 63, or are you referring
No, the paginated 63, and in the case itself, oh, I see. My learned junior.
63 in my bundle is the case of Vellum.
Yes, my lord, there seems to be something has gone wrong. Well, your bundle then, my lord, will be. My lord, did you see the paragraphs 1 to 4? Which I'll have to turn back. I'll have to use my. Okay, so paragraph. No, it is 63, huh? It's important, my lord, that I get this right, because this goes to the crux of remedy and conclusion. 63, the handwritten 63 on the top right hand side. Mine is this Vellum. Oh, you must have had it. You know what happened, my lord? If you turn to 63, 64, and I turn over the next page, I get to 51. So it's the earlier 63. You turn back to 51 and you go a page before, you get to 63.
Yes, that is a strange way of.
Late at night.
Well,
Yes.
incidentally, my bundle doesn't go to 51 after 63.
After 6. No, my lord. The earlier. No.
63 to 64.
Yeah, it goes 63, 64, 50.
Yes, but amongst all those numbers, where should I look now, Mr. Khan?
63.
63.
The earliest, there are obviously two 63. Go to Ibrahim, my lord. Ibrahim. Go to Ibrahim. You see, my lord, what's happened is there are now two 63s. Because what happened was, it went 63, 64, 50, and the numbers started again.
Yes.
I want you to go to the earliest.
So you're referring to the page 63, where the Ibrahim case is published. Yes, I've got it.
But I'm a bit concerned because then you would have missed my earlier reference to page 41 of Ibrahim, of the paginated bundle, but where Ibrahim is included in 41. You have that, my lord? I need to start there.
Yes. Yes.
On 41, the 4 prayers are described, 1, 2, 3, 4, which we mirror in our notice of motion, or in our default order. And what happens is the court goes through the facts and goes through the Roman law, Roman Dutch law, and it concludes gevolgtrekking on page 584 next to letter G.
Yeah.
It goes down a bit next to I. Dit volg dat die verhoorhof ooreenkomstig ons gedeldende gemeenereg geen regsbevoegdheid gehad het om die saak teen appellant te bewerken. Sy skuldig bevinding en vonnis kan gevolglik nie bly staan. And then the important proposition I wish to make in response to our learned friend for the police's comment about just and equitable relief of the whole jurisdiction question. Appellant's aansoek moes geslaag het. That's important. And then an important sentence, the next one, the key sentence. Hy was destyds geregtig op die bevelle aangevra en 1-to-1 keer van die kennisgewing van mosie. That's the important point. That although the court didn't grant 1-to-4, because now he'd been tried, convicted, sentenced to 20 years, it wasn't necessary to give the 1-to-4. They just have to set aside his conviction and sentence. But if your lordship goes back to 1-to-4, you know that the appellate division said he was entitled to 1-to-4, which is what we are asking the court to do. That's what I'm suggesting. So what we are asking for is your lordship to follow binding precedent on the question of what is the appropriate relief. Were your lordship to come to the conclusion that I would suggest anything, including that there was no power to use section 41 or any other section by the respondent, and there was no power to enter into an agreement, and there was no soil issue. Now, my Lord, I want to turn to something. It was then suggested that for a whole range of reasons, it was just and equitable that even if my client was unlawfully brought to South Africa, the trial should continue. Your Lordship heard that.
Yeah.
Now, what happened was, my learned friend, he set out a whole series of factors. Why should she go free, etc., etc.? What about the victims? What he did not mention was rule of law. The rule of law stands above us all. It makes us, and that's key. And that is said by the 4 judges in the House of Lords who rejected the minority in the House of Lords in Horseferry Road, ex parte Bennett, where that same argument was adopted by Lord Oliver of Almerton. And that you will see, my Lord, I hope I get the right page number, on page 90 of the bundle. Your Lordship will see Lord Oliver of Almerton's speech, they called it. On the right-hand side of the page, he sets out all the factors that our learned friend for the police set out to your Lordship, and said for that reason, even though Bennett was brought before the United Kingdom courts unlawfully, the trial should continue. Same reasoning. But the 4 law lords said, no, it doesn't work that way. And that goes to the Justice Stevens' comment in Alvarez Machine, which I've read to your Lordship this morning, where all of these issues were debated at length. And I cannot but ask that your Lordship have regard to what Justice Stevens said in dissent, again on page 120 of the US Supreme Court, where what he said is, look, South Africa. The Court of Appeal in South Africa, I suspect most courts throughout the civilized world, will be deeply disturbed by the majority. For every nation, and then I emphasize, has an interest in preserving the rule of law, is affected directly by decision, etc., etc. So it's a rule of law issue going back to Thomas Paine 300 years ago. And we would stand by that submission and suggest that your Lordship has no power to grant anything other than the kinds of orders as applicable to our case, that 1 to 4 of Ibrahim would have been granted had he not been tried and convicted. And it's interesting, but that's for another day in the future court, which is not bound by the appellate division. And that's how we would suggest that the court considers our learned friend's argument. It's an attractive argument, I have no doubt, but it's not for this court bound by Ibrahim to take a line, just cut through those paragraphs 1 to 4 of Ibrahim. Let the Constitutional Court do it if they say Ibrahim is wrong. As it pleases. Oh, sorry, my Lord, I just want to say one thing about our learned friends handing up those 2 documents, which are interesting. We have no objection to them being handed up. We scratch our heads as to why they're being handed up now. And I've read them, and they don't seem to help our learned friends for the department. They make it worse. Because there's a reference to Article 5 in the main treaty, the Lordship heard that, which is parties shall take measures to combat illegal migration and cooperate with regard to deportation processes and procedures. And then your Lordship asked the very interesting question, what about other documents? The framework. And the framework document doesn't say anything to suggest that Mr. Matthews and the others may visit the country of Tanzania or the Tanzanian resident of South Africa. What it does say in Article 5 of the framework document, that there is a combating of illegal migration and the various obligations under the framework that the parties enter into. But then, paragraph 4 of Article 5, it says receipt of deportees. I want to emphasize, my Lord, receipt of deportees. Where? In their country of origin. Nothing about receipt of deportees in the host country by the High Commission or the Home Affairs Division will be dealt with in accordance with domestic or national procedures. Clearly what this envisages is that when a South African is deported, let's say from Tanzania, in South Africa, not in Tanzania, they will be dealt with in accordance with those proceedings. So there's nothing to suggest in these documents that there's any power that South Africans or Tanzanians have respectively to enter each other's countries for purposes of combating illegal migration, etc., etc. I question the status of these documents, because it doesn't seem to me that they're part of South African law, they're out there. I'm not sure whether they're binding on the states. Or, importantly, my Lord, I don't. There's a question of Section 231. One of the Constitution gives the power to the national executive to enter into agreements between other countries, not law in South Africa, unless it's made an act of Parliament under Section 231(4) of the Constitution. So, your Lordship doesn't need to know, as a piece of.
Thank you, Mr. Campbell.
Well, I'm sorry, I don't want the second bite of Jerry. We have three submissions, one relating to urgency, which we just want to address. Will be very brief.
Yes.
My Lord, you've been referred to a correspondence to the papers that the applicant appended from page 51. We just want to highlight that the first letter that was addressed is 11 May. That's just shy of a month since she was, you remember, she was brought to South Africa and arrested on the 13th of April. The second is the 12th of May. And then the criticism with regards to the reply at page 36 is of course wholly unreasonable, because this reply that was given here is exactly in accordance with the first deferred respondents version that they've also given to this court. When they say the South African police were not involved in the arrest of the applicant and did not have any jurisdiction to arrest, that is perfectly correct. So the criticism and the attempt to rely on this a month later to say to the court, well, you should actually take a dim view of the respondent's conduct. I'm sorry, my Lord. No. The second issue is that the submission is made that the applicant seeks the same relief that was sought in Abraham, but that is not correct, my Lord, with respect. I ask you to page to Esther's Abraham at page 41 of the applicant's bundle. And if you would be so kind to just open
Which
your,
page 41?
41.
Which page 41?
I would have it as the first page 41. It's where it starts with empty estate, Judge of Appeal, where he's busy with his introduction.
Yes, it seems to me we've got the same one.
Yes.
Yes.
And then would you be so kind simultaneously to open your record at page 2, record of the proceedings here,
Yes.
the application. May I just direct your attention to paragraph 3-4 in that, where he's dealing with the orders that have been requested. Declaring that the applicant is entitled to be discharged from his imprisonment in detention at present, pending his trial under said indictment. There is no such period in the current notice of motion. It's not asked. This accords with the submissions that we've made to you, my Lord, and with respect to what we said is not against the rule of law. And it is not correct that the prayer in this application was drafted to accord with these prayers, because it doesn't. There's no, what the applicant moves for is that you should be discharged from detention, you must be released immediately, and that everything be set aside. That's it. So we join issue with the submission that prayer 4 of the Abraham case is definitely not there. Lastly, we've referred you to the Mohammed decision. The Concord dealt with the consent here. So to argue that my Lord, who is constrained by the rule of law, the President, the doctrine of legal precedent, to follow the SCA decisions, that you must ignore S versus December and related cases, where they expressly dealt with this matter, and where the Concord had the opportunity to deal with consent, and their remarks with regards to consent, remember, we deal with acquiescence, where they say that is to be doubted where somebody consents to be extradited or deported where his life will be in danger. That's the distinction we drew. You can read the discussion here as well. We join issue with these submissions with regards to that and the fact that it said that the first respondents argument flies in the face. You are bound by legal doctrine of legal precedent, and that's part of the rule of law. With respect.
Thank you, Mr. Snellenberg. Gentlemen, hopefully there will be an understanding that I need to digest all the submissions that have been placed before me today. Again, read your heads of argument, and then most importantly to pay due consideration to all the submissions and to come to a just conclusion. I do not intend taking weeks to do that. What I intend doing is to deliver judgment in this matter coming Monday, 5 June at 10 o'clock in the morning in this very same courtroom. Monday, 5 June, 10 a.m. in this courtroom, I will deliver judgment in this matter. Thank you, gentlemen. The court will now adjourn.